May I have your attention, please? All rise. County Municipal Court is now in session. The Honorable Donald R. Capper presiding. All those having business before the court draw nigh and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Welcome to Lawrence County Municipal Court. I'm Judge Capper. We have reviews for folks who have court orders to complete. And that's a check on that. So we're going to call those names, and when your name's called, come up to the table to your right.
State of Ohio versus Heather Rieger, case number CRB 20214.
Okay, this one actually is a sentencing, but we're going to take it out of order due to a medical. If you're wanting to be relieved of any of your community service obligations, you need to bring me a more complete medical report.
I don't care to actually do it. I'm just trying to get the medical part taken care of first. So.
Okay. All set. Your next hearing for June 30th.
Okay. Thank you. What time?
That'll be sentencing.
Okay. Thank you very much.
You're welcome.
Alicia Clay, Aaron Cron, Chase Lewis, James McClellan, Kelly Mintz.
Chase Lewis is here, 14-1065. You just have to pay off your funds. You can make your payments. Do you have a payment?
Yes, Your Honor. I'm going to make an online payment of $25.
Okay. It looks like you started some treatment on your own.
No, I've been doing it.
Okay. All right. It's a good report. Continue with that and make a payment. Set your next hearing for July 10th.
Thank you.
You're welcome. 9 o'clock, July 10th. Kelly Mintz, been called for, not here. Not completed. James McClellan. James McClellan is called and hasn't appeared. Aaron Cron.
Yep.
19-288. Okay, you've done some community service since the last hearing, and you still have fines to pay. Do you have a payment on your fines?
Yep.
How much are you paying?
I'm going to pay $20 later, as soon as I leave here.
Okay. Make that payment. You're going to make it at the clerk's office? You need to make it here at the clerk's office.
I'm going to pay it. Do I need to?
Yes, sir.
Okay.
And you still have 1 day of community service?
Yeah, I'm going to try to do it Saturday.
Okay. So Cooper will be looking for you, so go see the clerk. And so I need to set his for July 10th also when they mark it. July 10th will be good. Alicia Clay was called for, has not appeared, she hasn't completed. Will be a warrant issued.
Jason Taylor, Evan Holmes, Brandon Losey, Stephen Murphy, and Sarah Woods.
Jason Taylor, 77-22-66. Community service done, paying on fines.
Yeah, I was gonna make a payment when I get paid next week.
Okay, you still have about $1,000 left.
Yeah.
You're working now?
Yes, sir.
What's your work schedule?
I'm off Monday and Tuesday.
Set your next hearing for June 26th. 9 o'clock. That's a Monday.
Thank you.
Get this done, and quit coming to these hearings. Evan Holmes.
Your Honor, if I may, can that be resolved? Mr. Holmes, I believe is finished. He's stopping to get his community service to turn in something.
Okay, we'll recall it later in the docket. Brandon Losey. This is 22-17-64, 21-3000. And we have a report from OVP saying you are compliant there. You've done your community service, you have to pay your fines, and you made payment June 5th. Okay. Are you working now, sir? What are you
Yep.
doing?
Yeah,
What's your
I've been
work schedule?
I work all through the week, really.
So it doesn't matter if it's.
Yeah, it don't matter, yeah. I can just go in after.
Okay. I'll set you for July 17th.
17th?
Yes, sir, July 17th, 9 o'clock. Okay. Good job with your counseling. Keep it
Thanks.
up.
Thank you.
Sarah Woods.
She's in inpatient treatment. Derek's on his way with the reports now. She's compliant in all aspects, clean drug screens, no real infractions.
Okay, very good. She's got some community service to do. Is she at a point where she could come out and do some community service?
She will be here shortly. She's still in phase 1, so we're about a couple weeks out.
Okay.
And we need to see if we maybe can schedule her appointments, her court appearances on Monday, because she does thinking for a change as well.
Okay. That's no problem. I'll set her, and she's under some sort of supervision of common pleas also.
That is correct.
Okay, I'll set her next hearing here for July 31st. That's a Monday.
Thank you, Your Honor.
Since she's being supervised at common pleas also. July 31st, 9 o'clock.
Thank you, Your Honor. Thank you, sir.
You're welcome. Stephen Murphy is called.
Yes, Your Honor.
Okay, Stephen Murphy is on teleconference. It's case number 2270. And are you at the counseling center?
Yes, sir.
Okay. All right, so it must be going all okay. They haven't kicked you out or anything?
No.
Okay, do you have a time you're scheduled to complete there
I believe 13th.
of this month?
Yes, sir.
Okay. Then what's going to happen? What's your plan after that?
Outpatient at New Life in Cold Grove, and then getting started with the VA and get my community service and things.
Okay. Have you contacted the VA?
I was waiting till I was here, sir.
Okay, because they've got, so I assume you'll go to the Spring Valley facilities over in Huntington?
Yes, sir.
Okay. They got some good programs over there, and they work with us really well, so
Awesome.
I'll make a note that you are a veteran. And actually, I'll send it to, we have a liaison with the VA, and I'll send her your information, so
Appreciate
she
it.
can make sure you get in the system. Okay, I want to see you back at the court in Chesapeake then on July 10th. So you're going to be back in Lawrence County living, correct?
Yes, sir.
All right, July 10th will be your next hearing. That's the second Monday in July. Second Monday in July, you got to come to the court at 9 a.m. for a review.
All right, thank you, sir.
You're welcome. Okay, that finishes the reviews. We're going to do arraignments now. That's new cases, so if you're here for new charges, or if you missed a hearing on an old charge, you'll get called with the arraignments. You want to explain your rights. You have a right to remain silent. You don't have to make statements, but if you choose to make statements, what you say is on the record. It can be used against you if you admit something. You have a right to have a lawyer, to have a trial on your case. Sir, please leave your video off. And if you can't afford a lawyer, you can have one appointed. So you also have a right to bail and to make the state prove any charge against you beyond a reasonable doubt. Those are your rights. If you enter a guilty or no contest plea, you're waiving those rights, and you shouldn't do that lightly. You should enter a not guilty plea if you're not sure what to do, or if you want to talk to a lawyer, or if you want a trial on your case. Any of those reasons, you should enter a not guilty plea. Call the first case.
State of Ohio versus Caleb Langdon. Case number CRA 23332, CRB 23333, and TRD 23672, A, B, C, and D. Caleb Langdon. Did not check in, Your Honor.
All right, Caleb Langdon. This was an OSP citation. So there's going to be a CAPIS issued to the OSP for Mr. Langdon's arrest since he didn't appear today.
State of Ohio versus Michael McFarland. Case number CRB 23331.
Michael McFarland. All right, Mr. McFarland was cited to be in court. Today at 9 a.m. He's failed to appear, so there'll be a bench warrant issued for his arrest.
State of Ohio versus Kevin Browning. Case number TRC 23690, A and B.
Sir, are you Kevin Browning?
Yes, sir.
Mr. Browning, the state has filed a charge against you alleging that on June the 4th at 8:20 p.m. in Fayette Township, you were driving a vehicle while you were under the influence of alcohol, drugs, or a combination of those things. The state's alleging you refused to take any tests, and is also alleging this will be your first case, first time you've been charged with this type of offense, and that makes a difference on the penalty. So this is a first-degree misdemeanor. The maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. That's the most the court can impose if you're found guilty. There is, unlike most cases, don't have a minimum, but this one has a minimum that can't go below if you're found guilty. The minimum sentence is 3 days in a treatment program, $375 fine, and a 6-month license suspension. That's the least you can give if you're found guilty as a you understand that?
Yes, sir.
You're also charged with driving while you didn't have a license. You're charged with driving without a license. That's what's called an unclassified misdemeanor. Carries a maximum penalty of 500 hours of community service and a $1,000 fine. There's no jail time on that charge. Do you understand the two charges you're facing?
Yes, sir.
Do you understand the rights I explained that defendants have?
Yes, sir.
Any questions before you enter a plea?
No, sir.
What plea do you wish to enter?
I'd like to enter a plea of not guilty.
Do you want a lawyer appointed to represent you on these charges?
Yes, sir.
Do you have a job?
No, I receive Social Security.
That's your only income?
Yes.
I'll appoint Mr. Smith to represent you. He's right behind you, and Roger Smith. I'm entering a not guilty plea for Mr. Browning.
I'm here the next 4 Fridays, Judge.
Okay. Look and see what the docket's like. States. The 23rd,
We'll be fine, Judge.
2 weeks from today.
Yes, sir.
June 23rd will be the next hearing. It'll be a pretrial at 10 o'clock. Mr. Browning can sign a $1,000 signature bond. Anything else, Mr. Smith?
Not this time, Judge.
That's all. June 23rd, 10 a.m. is the next hearing.
Thank you, sir.
You're welcome.
State of Ohio versus Casey J. Jackson, case number CRB 22510, CRD 222595 A, B, and C, and CRB 22165 A and B.
All right, you are Casey Jackson.
Yeah.
He had a review last Friday, it looks like. Is that correct?
Yeah.
And you missed that hearing?
Yeah.
Do you have an explanation?
No.
And you have a case that's still pending. It wasn't just, some of it was reviews, but one of them is still pending. And it's Tyler's case. It's in
South Carolina.
Do you have an explanation for missing your hearing last week?
No, I just got caught up with work and.
Okay, well, you have to be here. Let's have a seat. We'll get a date when we know he's going to be back, and I'll call you back after and give you the date. Tyler Smith.
I'll check.
Okay.
State of Ohio versus Kayla Smith, case number CRB 23271. Mr. Stratton.
All right, we need Mr. Stratton in the courtroom. Mr. Stratton, this is your client, Kayla Smith. She had a hearing Monday, looks like she missed that, so
Yes.
have you talked with her yet?
We talked about her coming in as soon as
Okay.
possible. If we could just put it on the pretrial docket, I'll speak to her about it. It's a theft case,
So you just want to reschedule it for another day, or you want to talk this morning, recall it?
Can we just recall it?
Yes, I'll be recalled later in the lunch.
All right, let's step outside. We'll talk.
Okay, that sounds like we'll have some more arraignments here.
We're going to have several more arraignments here.
Okay, we're going to have some more arraignments if we didn't get to you. They're working on the paperwork. So we're going to start with some of the pre-trials from prior cases now.
State of Ohio versus Timothy Clark, case number TRC 2373 A and B.
Hey, we're starting some pre-trials.
This is Mr. Kermeen's case set for pre-trial.
Your Honor, I've discussed this with Mr. Hill this morning, and I think that the best way to proceed at this point would be I think we're going to have to file a suppression motion. We're asking for a pretrial on the suppression for a Monday or Friday in July.
Okay, when can you have your motion filed by?
In the next 2 weeks, Your Honor.
So, motion to be filed by June 23rd. And then pre-trial on the motion July 7th. Is that a good date?
I'm in a hearing July 7th, Your Honor. I'm here July 10th, or we could do after that.
July 10th. July 10th, pre-trial on the motion.
Thank you, Your Honor.
You're welcome. That'll be at 10 o'clock. Mr. Jackson, Casey Jackson, you come back up. This is on 22-510, 22-2595, 22-165. Your attorney, Mr. Smith, will be here on Monday, so that's the 12th. So your hearings continue to June 12th at 10 o'clock.
All right, thank you.
You're welcome.
State of Ohio versus Darius Branch, case number TRC 23508, A, B, and C. Mr. Stratton.
All right, well, let's read, it's not 10 o'clock yet, so we'll recall this later in the docket. There's Mr. Cremini, several people coming in.
State of Ohio versus Joshua Hitchman, case number CRB 23212, CRB 23107.
All right, Mr. Hinchman is appearing by teleconference. And this is Mr. Stratton's case.
Yes, Your Honor. Mr. Hitchman is sick. He asked me, well, should I not come? Or I told him at least appear by video, so he's here by video. Does Riverside have a report on you?
Left against that advice on May 20th.
May 20th? Okay.
So he left treatment on May 20th?
Yes, that's what happened.
Right now.
So, Your Honor, I'll just ask that this be set for another pretrial relatively soon.
All right, Mr. Hinchman, have you had a medical evaluation or anything of your condition?
He does, Your Honor, and he has sent me information on that. So I do have pictures that he sent me of that, so.
Okay.
And I provided that to the prosecutor.
All right, so when do you think you'll be able to attend? 2 weeks?
Yeah, should be 2 weeks.
All right, I'm going to set your next hearing, Mr. Hinchman, for June 23rd. You need to be here in person at that time. June 23 at 10 for pretrial, must be in person.
All right, thank you, Your Honor.
You're welcome.
State of Ohio versus Colton Landers, case number TRC 23475, A, B, and C.
And good morning, this is Mr. Each's case set for pretrial and
Your Honor, we've discussed this case some this morning, discussed possible resolutions. At this point, I would ask the court to set the misdemeanor case for a motion hearing. I filed several motions this morning. I have looked at Friday, June 23rd or July 7th. Really have no preference. Either of those dates is acceptable to the court.
Mr. Hill?
We're not opposed to either of those dates, Your Honor, and what we discussed was that I would review the motion and make a determination as to whether I felt there was merit to the allegations in there, or whether we needed to follow through with a hearing. So I guess we want to have a pretrial on the motion first. I don't care, whatever.
Well, what we could do it this way and not require, do a pretrial on the motion, not require the defendant to be
That would be,
present.
that's fine
You
with me.
can actually appear by teleconference if you.
I don't mind coming down, Your Honor. It's my client that's missing work.
Okay. So let's set it for a pretrial on motion. The motions are already filed.
Yes, sir.
Pretrial on motion June 23rd. If it's not resolved, then I'll set an evidentiary hearing.
Fine, Your Honor.
All right.
And I
Pretrial motions.
assume the felony will track temporarily with the...
So you waive time, just keep it here in this court?
Yes, sir.
And the state's
we'll need-
agreeable with that?
Oh, yes, Your Honor, and we'll need a time waiver on the felony in order to do that, and also, since there's a motion pending, technically there's a time waiver anyway, but I'd go ahead and just put it on this entry as well.
I don't have a problem with that.
All right. June 23rd at 10 o'clock will be the next hearing, pretrial on motions, pending motions.
Thank you.
Well, defendant does not have to be here June 23rd. He's welcome to be here, but he doesn't have to be.
Thank you, Your Honor.
State of Ohio versus Michael S. Clay, case number CRB 20-1023, CRB 18-796, CRB 18-251. Did not check in, Your Honor.
Michael Clay is Mr. Steyer's case. It's set for 10. It's 9:55, so we'll recall it after 10 o'clock.
Thank you.
State of Ohio versus Edith Gregory, case number CRB 23-121.
Mr. Steyer's case, set for pretrial. This is on the 90-day continuance.
Yes, and there's a co-defendant, what's his name, I'm sorry?
Donald Mapes.
Mr. Babes,
Is he here?
co-defendant, he's also here.
Okay, you can come up.
I don't know who his attorney is offhand.
Who's your attorney, sir?
I can't remember his name.
Mr. Morford.
I'm not sure if Mr. Morford's here
I
yet.
was going to say Irwin.
Okay, he's here, apparently.
State of Ohio versus Donald Mays, case number CRB 23-120.
I thought I just heard he came in. At any rate, this is a 90-day continuance that was to be dismissed upon, without problems in the 90 days, no court costs required, and I don't believe there have been any problems. So I would just ask on my client's behalf that the dismissal go forward.
Well, I don't think Mr. Morford would object.
Mr. Morford is here, Your Honor.
All right, there he is. All right, come on in, Mr. Morford. This is Donald Mapes. This is a 90-day continuance case without court costs, and I think the state's about to dismiss the case against your client. Now, I'm assuming you don't have an objection to this.
You taught me when to be quiet.
Is that correct, Mr. Wood?
Well, that would be correct. We want to make sure there haven't been any further problems. So we're okay with the dismissal of both cases.
All right, both cases are dismissed.
And
No court costs.
if they need to pick up a copy of that, would they pick that up from probation department?
That or they can get it from the clerk's office.
Okay. Maybe you'll wait around maybe 20 or 30 minutes.
Without court costs. No court costs.
Thank you, Your Honor.
You're welcome.
Thanks. Or you can come back another day. Okay.
State of Ohio versus Buddy Hardy, case number CRB 23-287, CRB 24-600, and CRA 1864A and B, PRC 1870A and B.
Mr. Steyer's case.
Your Honor, I have filed and received discovery on this matter. I'd like to have an opportunity to meet with my client, to take a look at it, so we would be willing to enter a time waiver for a continuance to accomplish that.
Okay, and it looks like there's a case, I don't know if you were aware, there's a 23-287, which was a possession of marijuana, so I'll point you on that.
I wasn't aware of that, Your Honor.
Me neither. From May the 10th of this year.
Has it been arraigned?
It was waivable according to this, and that's, I don't know if there was some indication he was gonna pay, but he didn't pay it.
Okay, well, just in case, we'll formally enter not guilty plea, waive reading, and ask to have it set for pretrial concurrent with this other matter.
And there's also a, on this one, he hasn't been served, I'm told. It's case number 22600. It's a criminal damaging charge from last fall, September 20th.
Then, Your Honor, again, I would waive reading, enter a plea of not guilty, and ask for this also to be set alongside the OVI. Now, I haven't done any discovery on these other matters, obviously, so I would probably want to supplement my discovery to include these issues and take a look at that. So maybe go out a little bit further than we would have expected otherwise, because I'm not just dealing with what I've already got.
Okay, let's see.
I also don't know when you're looking to set cases anyway, so it may be a moot point.
It was probably going to be June 23rd or after. Do you have a preference?
I'm not available the 23rd or the 26th. I am here. Can we do the 7th of July?
Should be okay. Let me check. Yes, July 7th.
So write that down.
For all matters before the court for Mr. Hardy. At defendant's request.
$10. So I'll do discovery on these other matters and get those figured out too. So that's your copy though. Thank you, Your Honor.
You're welcome.
State of Ohio versus Letitia Walker, case number CRB 22429. She does not check in.
Your Honor, this matter was going to be dismissed upon payment of court costs. I don't know if they've maybe been paid in the interim, because last time we were here, she said she needed some time to get them paid, and we reset to today to allow that.
And it doesn't look like anything's been paid.
All right, she has, other than today, been pretty good about keeping up with me and making sure she gets here, so I would ask for 7 days before a warrant goes out, and I'll attempt to get in contact with her.
Okay, it'll be dismissed if she pays the cost.
Thank you.
State of Ohio recalls Michael S. Clay, case number CRB 201023, CRB 18796, CRB 18251.
Michael Clay, it is slightly after 10 now.
Your Honor, this is an older case from a couple of years ago where Mr. Clay allegedly failed to appear, I think back in either 2020 or 2021. I wasn't even aware he had come back into contact with the court and got put on the docket until I saw him on the docket this morning.
He's supposed to be at Southern Hope. That's what he told me when he was here last.
He's there. He's not on the video by any chance. No, there's DB and LJ. Do we have contact information for Southern Hope?
I'm sure, I don't have it, but Mr. Cooper can get it.
I'll step out and get that between cases and try to make it and see if we can get it recalled.
Okay. Recall later in the docket.
Thank you, Your Honor.
State of Ohio recalls Darius Branch, case number TRC 23508, A, B, and C.
Okay. Darius Branch is appearing by teleconference. It's Mr. Stratton's case and set for pretrial.
Your Honor, Mr. Darius Branch is at the hospital. They just had a baby in the past couple days. Anyway, it's set for a pretrial today. We're still waiting on urine results, so we just asked it to be reset.
Okay. Let's see, May 7th.
Be about August the 7th or thereabouts.
That long?
6, 7, 8, 3 months.
Here.
Just a second.
That'd be 13 weeks.
Well, 3 months from May the 7th, June, July, August,
But won't that be out of time, out of rule by then?
90 days. So it may not be, it might be August the 6th or August the 10th, and I could put a final date on it, but generally it's 90 days to try the case.
It has to be set within the,
Well, let's set it sooner than that. 'Cause that doesn't leave any.
Oh,
wiggle
certainly.
room.
And Your Honor, the results are coming back sooner than the 90 days. We had that problem for a while, but
Okay.
they've been coming back more often.
Oh, you were just saying that's when the time's
That's
up.
when the time,
I
I'm
thought
sorry.
you were saying that's when the test would be back. I said,
well, that's the way I took it.
No, I'm sorry.
Okay, because I have been saying usually about 10 weeks at one point, so you think it's sooner than that? So we're only like 5 weeks out now, so when we come back July the 10th, that gives you a month.
I think that's a good.
Are you available then, Mr. Stratton?
Yes, that sounds good, Your Honor.
All right, July, Mr. Branch, your next hearing is going to be on July the 10th. That's second Monday in July at 10 o'clock. Congratulations on your baby.
Thank you, sir.
You're welcome.
State of Ohio recalls Kayla Smith, case number CRB 23271.
Your Honor, I just asked this to be set for another pretrial.
Okay. June 23rd?
Yes.
Available then? June 23rd for pretrial at 10 o'clock.
Thank you.
State of Ohio recalls Darrell Campbell, case number CRB 23106.
This is Mr. Stratton's case set for pretrial.
Your Honor, we have been going, just checking up on this case. It's still set for pretrial. There's been no conviction or plea. But we just come back to see how he's doing.
Is he doing counseling now? And he's living in Houston?
Yes. He graduated school.
He graduated high school, so that's a good thing. His mother says he's acting and behaving much better. Sure wish we could just bottle this, what we have right now, and keep it that way forever.
Yeah, but.
Now, we also know that Mr. Campbell knows better than to treat his mother this way.
Yeah.
And I just happen to have known Darrell and his mother for many years for reasons just like this, and she's struggled to, because she loves him and she wants to make sure he has a good life.
Yeah.
But one of the things that needs to happen is he needs to have account for what he's done. So our recommendation today was that if he entered a guilty plea, because we believe he is guilty and he knows what he's doing, that we would recommend a suspended 30-day jail sentence and probation and stay out of
I
trouble.
don't want to go to jail.
You're not going to jail?
Yeah, I'm all right.
Okay. Your Honor, he's fine with taking a plea today. We'll plead guilty to the charge, ask for suspended time, and recommendation to prosecutor.
What's your plan now that you graduated from high school? What do you-
I try to find me a job.
Okay.
If I can't, I don't know what I'm gonna do. Just sit at home, watch TV, mind my business.
Everybody's got to have something to do, don't they, Judge?
Yeah, I think that would be important.
Yeah.
Get a job, and now that you're an adult, I mean, your mom had to take care of you
Long time.
before. The law required her to take care of you. She doesn't have to take care of you now. She has no obligation legally to take care of you. But she gets to make the rules. If you want to live under her roof, you got to follow her rules.
I will.
Or get out.
Yeah.
Go make your own way.
Yeah.
The person that pays the bills
Is the boss.
gets to make the rules.
Yeah, the
If you
boss.
don't like the rules,
Just did
go
that.
make your own way,
Yeah.
okay? All right, anything else that you all want to tell me before I do this?
No, Your Honor.
All right, I'll accept the guilty plea. I won't impose a fine because I don't think he's got any ability to pay a fine. At this point, he's not working. I will order him to pay the court costs. And 30 days in jail, all suspended. So you got 30 days hanging over your head if you have, this was pretty aggravated what I read in the affidavit. So if you pull something like that again, you've already got a month in jail before you ever get out of the chute on the next charge.
Yeah.
So don't do it.
I won't.
All right, 2 years of level 5 probation. I'll make it non-reporting probation. I will set a review hearing for him on September the 18th. He'll need to go meet with the probation officer, and then he's free to go right after that.
All right, thank you, Your Honor.
Call us if you need anything, okay?
No community service.
State of Ohio versus Sarah Osborne, case number CRB 23164 A and B.
This is Mr. Morford's case, and it's set for a pre-trial.
Hey, Butch. How's the children's services case going? Okay, that's good. So what I would suggest here is that it have a plea and we will delay sentencing. And as long as she finishes her case plan, we won't recommend any jail time. Yeah, bad enough.
So these two charges, no jail time. Do your case.
Judge, I think we're going to have a change of plea. Be guilty. In exchange for what I understand Mr. Hill's recommendation to be.
All right, is that correct, Ms. Osborne, or do you wish to change your plea?
Yes, sir.
What's the state recommending?
Well, Your Honor, Ms. Osborne is currently involved in a case in the juvenile court with Children's Services. And we want to encourage her to make sure she finishes that case plan and is able to get the children back, because that's our main goal, is to put her in a better place. So I think that we would be willing to do either delay sentencing and follow up on it, or we would recommend a 6-month suspended jail sentence and have her on probation. We'd be willing to do either.
Do you have a preference?
I like the first option the best. I'd like to let her do the case plan and show that she is serious about changing the issues that bring her here, Judge.
Okay, maybe she could even get a dismissal.
I don't know that Mr. Hill is going to go there.
The reason...
Well, I understand, but maybe the court would. You really pull I'm a softie. He's hard.
Your Honor, and I don't think I'm that hard, first of all. But also, we had her before in a similar situation, and we just want to make it stick this time. We want to make sure that when we leave her, that she's in a situation where she doesn't get back into it again.
Okay, so let's make a good record. So, Ms. Osborne, you are pleading guilty to the endangering children charges filed against you. There's 2 of them. Is that correct?
Yes, sir.
And I'm going to delay sentencing while you participate and a plan with Children's Services to restore relationships with your children. That's the goal, right?
Yes.
So are they in a relative placement now? Or are they-
No. They're in the foster home.
They're in a foster home, okay. Well, how old are they?
2 and 3.
Well, this is really important, so, is there, let me look at the affidavit here.
Judge, if I recall correctly, this is the age you say when the children's brains are really being developed, like 8% of them between 0 and 3.
Yes. That's what Dr. Davies tells us in his studies. I mean, I don't see anything. Is there any suspicion that there's substance use involved in this, or I don't? It's not overtly stated in the affidavit.
From what we had, we didn't have any indication of that. Was that part of her case plan that she had a substance?
There's been no allegations of substance abuse that I'm aware of, Your Honor, and here or in Children's Services proceeding.
Okay, well, we need to work really hard at this. I know young children are demanding. It takes a lot of energy. But this is what you got to do. This is the time of life where you've got to do it. This is the most important thing. This is your most important thing that you have to do in your life is care for these children because you are shaping them right now. And this is not, I'm going to say it's not irredeemable, but it's not a good experience. You know, for children to be placed in foster care, we talk about adverse childhood experiences and what that does to kids later in life, manifestations of bad behavior later. The thinking is the more of these bad things that happen to you when you're young, the more likely you are to act out and be involved in the criminal justice system, have substance use problems, have marital problems. Those things all come to roost later in adulthood. So you're planting bad seeds right now for your children. And you don't want that, I don't want that, nobody wants that. So you really got to work at this. So I'm going to delay sentencing. What's going to happen, I'm going to come back and I'll get reports from Children's Services and how you're doing, and then we'll go from there. I'll send you eventually work. I mean, I have the option that I could even dismiss if I was really concerned or really convinced that you really turned the corner and this wasn't going to happen. That's what we want to see. Not any further issues with child care in the future. So, excuse me. Let's come back in about a month and see where we are. What's your schedule mid-July, Mr. Murphy?
21st?
Well, I'd like to do it a little sooner than that. How about the 10th, 17th, 14th?
10th, I'm here, Your Honor.
July 10th. It'll be a sentencing hearing. And I'm going to need a report from Children's Services.
Thank you, Judge.
You're welcome.
Christopher Roberts, William Elton.
State of Ohio versus Robert Byers Jr., case number PRC 222120, ABC, CRA 22489, ABC and D, CRB 22488.
Yes. So he's still in the sober living facility?
Yes, sir.
It's a good report. We've been at this for a while. Are we at a point where we can conclude the sentencing, Mr. Hill?
I was thinking the same thing, Your Honor. He had previously entered a guilty plea to the OVI, and it was marked as a second offense to begin with, but we determined that the prior was in an unknown court in Kentucky, so probably would not be able to be used as an enhancement as far as the mandatories. So we don't have any objection to the treatment that he's gone through, standing in place of the 3-day driving school. As far as the felony possession charge that's pending, it's been, well, since July of last year, he's made steady progress except for one incident. So if the court was of a mind that he had made significant enough progress for us to dismiss that charge, we would entertain doing that at this point.
Okay.
I know that he's done very well. I know he's taken it seriously.
And there was, let me look at those, there was a bunch of, there was also endangering children, and that was a misdemeanor, and possession. There's more than one possession of this. Just on the, I think with the basis that there being different substances.
Yes, Your Honor. It all occurred at the same time, I think.
What's the status with your children now, Mr. Byers? I see there's a report about your 10-year-old daughter that you had.
Yeah, I go home every weekend and see her.
Okay.
We wouldn't ask for a plea of guilty or a conviction on that endangering charge, considering how well he's done in every other respect.
So you're okay with dismissing that?
Yes, Your Honor.
All right, well, let's proceed with the case that I'm going to sentence you on then. That's 22-2120 A, B, and C, which is the OVI driving under suspension, and there was a headlight out too. So those charges he's already pled guilty to, and I'll go ahead and sentence. Mr. Morpher, is there anything you wish to say, or Mr. Byers wishes to say on those?
I'd just like for you to take into consideration, Judge, the efforts that he's put into treatment, and hope he stands before you a changed man and ready to discharge his responsibilities as a father.
Yes. Well, the things that I said in the prior case apply to all of us. All of us that are parents or grandparents. What we do, what we demonstrate to our children, people that are watching us that are younger, is one of the most important things we do, and has a huge impact on them. So if you can't find it in yourself to be motivated to get clean, stay clean for yourself, which should be enough, do it for your family, because it has a big impact on them, especially your children. The studies show. Yeah, it's not a guarantee. You can do everything right and your kids can still go haywire and get involved in substances and so forth. But the studies do show this. If you're doing that, the odds go up that your kids are going to do it. You just increase the chances that they're going to be involved with substance use if you're involved in it. And it's substantial. So that should be enough to keep people on the straight and narrow, but it's hard. I know it's hard. You've got a good start, but you're going to have to continue to work at this.
Oh, yeah.
Okay, so this is 22-2120A on the OVI. I'm going to impose a $500 fine, order you to pay the court costs, You get a 6-month license suspension, which actually is going to be out, but you'll have, if you want, your license was already suspended before this happened, so you'll have to deal with the BMV to get reinstated. Whatever, you know, they're going to have some hoops for you to jump through to get your license back. But the court suspension will be over once it hits. We'll report it, but it'll already be over. By the time it hits there, it's over. You've been under suspension since you got this. And I would encourage you to work on getting your license back. 20 days in jail. I'll suspend all the jail days. On the condition you do 5 days of community service. Continuing outpatient treatment as recommended. So outpatient treatment as recommended, so you're still, that's what you're doing now. I want you to continue as long as it's necessary. No driver intervention program because of the other counseling you've done. 2 years of level 4 probation. I would have said, I'm not going to go to September for his review because of the issues here. I want to see him before then. Let's make it August 7th as his review hearing. First Monday in August. On the B case, which is a driving under suspension. Look at the officer's report. Okay, it really was no bad driving. You got pulled over for having the headlight problem. Okay, $50 fine on the driving under suspension. And then on the headlight, a $10 fine. And same review hearing date, August 7th. 9 a.m. So you'll need to go meet with Mr. Major about his probation on those.
No.
And then on all these other cases, 22-489, 22-488, I'm dismissing all those due to your efforts in treatment.
Thank you, sir.
You're welcome. Congratulations. Good luck. We'll see you August 7th, and just keep working at this. You cannot get to the point where you think, well, I've got this lit and it's done, I don't have to work at it anymore. No, you got to keep working, as we all do. Okay? August 7th, go see your probation officer.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio versus James C. Jones, case number TRC 23536.
Your representation, James?
I am, Your Honor. We've waived reading the complaint under a not guilty plea, asked for an OR bond be set. And Your Honor, I have an agreed entry. Mr. Jones's vehicle is currently impounded, and we'd like to have it towed to his residence and immobilized there.
And Mr. Heald's agreed to that?
Yes, Your Honor.
Yes, okay. I'll sign your entry. And when do you want to come back for a pretrial?
We could come back July 17th, Your Honor.
Yes, with the time waiver. July 17th, at defendant's request, will be the next pretrial at 10 o'clock, and you get your entry.
I do, may I approach?
Yes.
No, that's the mobilization.
State of Ohio versus James C. Preston, case number CRB 23305.
And sir, you're James Preston?
Yes, sir.
And you told me at the arraignment you were a hiring attorney. Have you been able to do so?
No, she cost me my job.
So you asked me to be considered for court-appointed counsel now?
Yes. Yeah, I tried to come in like 2 weeks ago, 3 weeks ago, and they told me I had to come into court to request it.
Okay.
So,
So at this point, you have no income?
no income.
All right, Mr. Morford, I'll appoint you to represent Mr. Preston. This is a M1 domestic violence charge. Looking at June 23rd or after for a pretrial. Do you have a preference, Mr. Morford? I don't, Judge. June 23rd will be the pretrial at 10 o'clock. Okay, we've got some paperwork on our new cases, arraignments, so we're going to go ahead and do those now.
State of Ohio versus Lacey Hoagland, case number CRB 23345. Lacey, Hougland.
Lacey Hoagland. I'm going to pass this because it doesn't, there's no proof of service in the file, so it'll be passed for service.
State of Ohio versus Heidi Meadows, case number CRB 23341.
The bailiff is serving the defendant with copies of papers. Are you Heidi Meadows, ma'am?
Yes.
Ms. Meadows, it's alleged that at Fayette Township on June the 5th of this year, you deprived purposely Walmart of property without their consent. That's a theft offense, maximum penalty is 6 months in jail, $1,000 fine. Do you understand the charge?
Yes.
Do you understand the rights you have as a defendant?
Yes.
Okay, there's a companion, so we'll call it to
State of Ohio versus Roger Meadows, case number CRB 23343.
And the defendant is being served with a copy of the charges. And sir, you're Roger Meadows?
Yes, sir.
You're also charged with a theft offense, June 5th of this year, Fayette Township, that you tried to deprive Walmart of property without their consent. Maximum penalty, 6 months in jail, $1,000 fine. Do you each understand the charges?
Yeah, but it's a misunderstanding. Yeah, I understand the charges.
All right. So I take it from that, you wish to enter a not guilty plea, sir?
Yes.
Yes,
What
sir.
about you, ma'am?
Yes.
Same?
Not guilty.
Do you each wish to be considered for court-appointed counsel?
Yes.
Are either one of you working?
I do, he doesn't. He's filed for his disability, but it hasn't went through yet.
Okay, what do you do, ma'am?
Rest care,
You paid by the hour?
yes.
How much per hour?
I think it's 11.
How many hours a week?
Sometimes 40, sometimes 30, just depends.
Okay,
I know you have to ask that.
well, I have to determine your gross annual income, so I gotta do some math. Do you know what your gross annual income is? You file an income tax return?
Yeah,
Do you have dependents?
yes.
Tell me about your dependents.
We have one 8-year-old daughter.
Okay, if you're making $11 an hour, you're gonna be eligible for court-appointed counsel and with a dependent. So, all right, Mr. Steyer, I'll appoint you to represent Ms. Meadows. And Mr. Stratton, around. I'm entering a not guilty plea for both. He's left.
I'm not gonna say he left, but I can't find him.
Okay.
He didn't say bye, no lie.
All right, Mr. Smith, then I'll appoint you
Yes.
to represent Mr. Meadows. Not guilty pleas are entered for each, and I'm looking for pre-trials, you're not available June 23rd, right?
I'm not available the 23rd, but I'll be back the next week. The next Friday's my first day back.
I'm here the next 5 Fridays, Judge, whatever's good for Luke.
Here the 7th.
Is July 7th available?
It is.
Smith, okay, July 7th works for both attorneys, so July 7th for pretrial at defendant's request. And they can each sign a $1,000 signature bond.
Sign this right here. Sign me right here.
Thanks, Judge.
Well,
State of Ohio versus Holly Elkins.
Okay.
Case number CRB 23342 and CRA 04179.
Yes.
Amber, you Holly Elkins?
Yes, sir.
You have a theft offense charge against you, 23-342, alleging that June 5th in Fayette Township at the Walmart, you purposely deprived Walmart of property without their consent. Maximum penalty 6 months in jail, $1,000 fine. And then there's an old case from 04179. It was interference with custody charge that it looks like you pled to, and it was never completed, so that's still pending. Do you understand these charges?
The first one, yes.
Well, let's see if we got the right person. Date of birth, March 22nd?
Yes.
Okay. How do you plead to the new charge?
Guilty.
How do you plead to the allegation that you didn't complete what you were ordered to do back in 2004?
I don't remember that, I'm sorry.
Okay, I'll take that as a not guilty.
Yeah. Well, I'm probably guilty if it's on there.
We've had people get their identity stolen, so that could happen. Do you want to talk to a lawyer about that?
No.
It was,
The only other time I got in trouble was in 2004. I was just turned 18 and my friend was like 16 and we went to the Ashland Mall and I think I got in trouble for that because I was 18 at the time and she was underage. So I'm pretty sure that's what that's from. But I thought I finished that in 2004.
well, Mr. Smith was returning.
Is Christopher Roberts here?
He's in the car. Oh, his was dismissed.
This had to do with an Amanda Reed.
Yes. She was underage at the time. I just turned 18.
Okay. So, and you're sure you don't want a lawyer?
Yes.
And you admit that you didn't, you had a review hearing back in October of 2004. It's alleged you didn't show up for it and you got 10 days of community service and 5 days of court costs that were never paid.
Yeah, I thought I did a community service here.
You're not showing anything.
I know.
So, do you admit you failed to appear and failed to do what you were ordered to?
I remember doing community service, but I know I probably didn't pay, no.
Okay, well, I'm going to take that as a not guilty plea, so I'm going to reappoint Mr. Smith, and since he's going to represent you on that, he probably would like to have both cases. So
Yes, Your Honor.
she has a pending new shoplifting at Walmart charge. She has an old case from 2004
That's what I'm not remembering, okay.
that was charged as a felony, but it looks like from the record it was reduced to a misdemeanor, and so alleged she didn't show up for a review hearing or do what she was ordered to do. So I'm going to appoint you on both matters.
Yes, sir.
And you're available June 23rd?
Yes, sir.
June 23rd will be the next hearing on both. She can sign, she may have a bond up. Do you have a bond up? You didn't post a bond?
No.
All right, she can sign a $1,000 OR bond. June 23rd is your next hearing on both cases.
Your Honor, if I may, Ms. Elkins has a co-defendant named Christopher Roberts, and there was some question about proof of service, but Ms. Elkins just stated that he's actually in the vehicle and on the property of the court, so.
Can we have him serve? Well, Mr. Cooper will go serve him.
Thank you.
We finished with her, Judge, or are we still waiting for?
Mr. Cooper's going to go serve the other person. So,
State of Ohio recalls Caleb Langton, case number CRA 23332.
he doesn't want a warrant, he needs to come in.
CRB 23333.
Caleb Langdon, is that you, sir?
Yes, sir.
Have you received a copy of the charges?
Yes, I did get a copy of the charges.
Okay. The most serious one is 23332. It's a possession of drugs charge. It alleges that on June the 5th in Fayette Township, you not only possessed or used clonazepam, a Schedule 4 substance, and then you've got a prior conviction for a drug offense, so that makes this a felony 5. Maximum penalty, a year in jail, $2,500 fine. Case number CRB 23333 alleges that you were also in possession of marijuana in an amount less than 100 grams. That's a minor misdemeanor, maximum penalty is $150 fine. And you got traffic charges, 23,672 A, B, C, and D. The A case alleges that June 5th at 2:20 a.m. in Fayette Township, you were driving a vehicle while you did not have a driver's license. So that's an unclassified misdemeanor, maximum penalty $500 community service, $1,000 fine. You're also charged with not wearing a safety belt. That's a mandatory $30 fine if you're found guilty. Not using a turn signal. That's a minor misdemeanor, maximum $150 fine. And distracted driving. That's minor misdemeanor, maximum penalty $150 fine.
Okay.
Do you understand these charges?
I do, sir.
Do you have the money to hire a lawyer?
I do not.
Are you working?
No, the court date where I had to go to court the same day that I got pulled over, they exterminated me from my job.
Okay, where were you working?
Brand Safeway in Huntington.
Okay, what were you making per hour there?
$12.25.
You have any money saved now?
I just about $100.
Okay, I'm going to go ahead and appoint counsel for you. I'll appoint Mr. Morford. Caleb Langdon, he has the most serious charge is a possession charge, felony 5. And what's the state's position on bond? And let's see, you are Scotttown.
Yeah.
A lot of good people from Scotttown, including Mr. Hill from my ancestors.
Way back.
Yeah, it's a small little town, ain't it?
Well, Your Honor, it is concerning whenever there's allegations of possession of drugs. I think this would be a misdemeanor, but for the fact that he was convicted previously on another similar charge. We would like to see him be assessed for some treatment in order to maybe keep us from having to go forward to a felony conviction on a drug charge. And we'd be willing to keep the case here and allow him to do whatever the counselors suggest for him, and then come back at a later date. If he's successful, we would probably agree to dismiss the charges. Now that doesn't, there's still the no operator's license charge and the distracted driving charge, but the major charge is the drug charge.
Mr. Morford, do you want to talk with him, or?
Can I have just a second, and then if he wants some further discussion, I'll have you recall. Do you understand?
Yes. During the treatment. My dad, he said right there, they gave me a new life for him to get treatment. I had a couple.
Are you willing to do that?
Yes.
That'd be great to take you.
Yeah, he said Monday he can do an assessment.
Your Honor, my client has taken upon himself to speak with a representative from New Life Recovery. He has an assessment scheduled for Monday, and he would take Mr. Heald up on his offer to go through treatment and see if we can come up with a favorable disposition if he does his treatment.
Do you have a Ohio Medicaid card?
Yes, I do. I got CareSource.
Okay. Well, we want to change it a little bit to get a better idea of what we're dealing with. I'd like for him to do a urine screen, and then we'll have some folks that are here. Taylor, you want to speak with him?
Yeah.
Let's do a urine screen, have him speak with Taylor, and we'll come back and finalize what our bond is going to be, what kind of treatment he's going to need. So you're going to do your urine screen so we can see what we're actually dealing with. So go out in the lobby, they'll show you where to go to get your urine screen done, and then I'll recall you.
State of Ohio versus Dylan Titan, case number CRA 22473, CRC 222096 A and B.
This is Mr. Morford's case. Looks like there was a failure to appear on May 26th.
Why did you miss court?
Do you want to recall this, Mr. Morford?
Please.
Let me give you what I'm seeing. Way back, and there's a felony in here. He was referred to PROACT, but I don't think that happened. He was at OVP. He had a job at Fletcher Mining, so that's a pretty good job initially. The last report I have from OVP, I'll just read into the record. I'm writing this letter to inform you that Dylan Hyden gives the date of birth, is not currently a patient with OVP Health. His last known appointment was February the 13th of 2023 at our Huntington office. At that time, he was compliant with the requirements and his claims were compliant. This letter's dated May 26th. He's attempted to complete 3 more assessments to be readmitted as a patient at our outpatient offices in Proctorville, but he never showed up for any of these appointments. So he's missed 3 prior assessments to get back into treatment, and I'm going to suggest, okay, he needs to do a urine screen today too, so to figure out where we are. He needs the urine screens, and then talk with him, and we'll come back and decide how we're going to handle this.
Thank you, Judge.
You're welcome.
Ready for Dodge County Jail at this point.
Okay, we're going to the jail for some teleconferences now.
State of Ohio versus April Combs, case number CRD 23346. Todd Daniels is on there.
Okay, we need April Combs at the jail for arraignment. You want Mr. Hyden's file, Mr. Morton, since you don't have the file yourself? And let us know when you're ready to recall.
Here at the court, State of Ohio versus Jessica Chesney, case number CRA 22633 A and B. Jessica Chesney. Jessica Chesney.
This is set for preliminary hearing.
How are you doing?
May I approach, Your Honor?
Yes.
Ms. Chesney has graduated from our residential program and is currently residing in our sober living. She's working on getting a vehicle and finding permanent placement for employment.
Okay, pretty good report. That looks like there's things you're still working at. What's your plan now? You're an outpatient.
I'm going to continue an outpatient until I find a permanent job.
And your children are, where are they now?
They're with family.
Okay, relative placement. But you're getting to see them, have some
Yes, weekends I see my
relationship.
children, yes.
Okay. Mr. Hill?
Your Honor, this is one that was been discussed with me by the QRT program. And she has made significant progress, and I guess our proposal would be to go ahead and nollie the charges and have QRT supervise her. What that requires, however, is that originally one of the charges was a third-degree felony, and they can't accept a third-degree felony, so I'd have to move to amend it to a fifth-degree felony and then nollie it. So with the court's approval, that's what we're going to do.
Okay. Megan's here from QRT. You're agreeable with what Mr. Woods
Yes, sir.
represented? So that's going to be, which case number is that? 633A.
Yes. Is there a different section number?
Yeah, just be under the same section number, as I understand it.
Yeah, there's various levels under that one section.
And there's no objections?
No objection, Your Honor, no, we would join the motion.
All right, it's amended to an F5 and then nollie to QRT. Both 633A and B are nollie to QRT for further follow-up. So it's my understanding that if things don't work out well, will either be brought back here or taken to the grand jury. All right, so do you need to speak with her today?
Yes. I'll meet y'all.
Before you leave, please speak with Megan, and good luck to you, and congratulations on being successful so far.
Thank you very much.
Good work.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Bobby Johnson, case number CRA 23235. Bobby Johnson.
Mr. Steyer's case set for preliminary hearing.
He's on his way in here, Your Honor. Get some mobility issues. Your Honor, this is an open dumping case. I'm not sure what they're actually called, enforcement officer was here this morning. He has spoken to Mr. Johnson's son, who's actually also here in the courtroom, who is assisting in addressing the situation, and he needs some more time to work on that. So if we could go out, it's a little long to ask, but because his son's employed full-time, so he's coming and helping him out when he's off work. If we could go out about 6 weeks, I think we could get this situation addressed, and we would waive time constraints to accomplish that, of course, Your Honor.
That would be July 23rd.
Oh, July 23rd, I have am I on the wrong? No, I've got July 23rd as a Saturday.
I'm sorry,
Sunday.
I was looking at June. That would be July 21st.
I have a jury trial scheduled that day, Your Honor. I'm here.
24th?
I'm here the 24th.
All right. At defendant's request, case is continued to July 24th for another preliminary hearing, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you, sir.
State of Ohio versus Christopher Roberts, case number CRB 23348. Christopher Roberts.
And sir, are you Christopher Roberts?
Yes, sir.
Mr. Roberts, it's alleged that on June 5th of this year, you tried to defraud Walmart of property, and that's in Fayette Township of Lawrence County. It's a theft charge, maximum penalty is 6 months in jail, $1,000 fine. You understand the charge?
Yes, sir.
You You understand the rights you have?
Yeah.
You have a right to remain silent. You don't have to say anything. If you do make statements, they can use against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove any charge beyond a reasonable doubt. Those are your rights. Do you understand those?
Yes, sir.
How do you wish to plead to this charge?
I wasn't even aware that I had to be here today. They told me that they wasn't even going to charge me at the time, so I'm kind of surprised. So I'll plead not guilty.
You want a lawyer appointed to represent you?
Sure. Yes, sir.
Do you have a job?
No.
Do you have any income at all?
Disability.
Okay. Mr. Thompson?
I think he had to leave.
Mr. Thompson.
He did leave.
Stratton leave too, or?
He did leave.
Yes.
All right, Mr. Steyer. You have the code.
I've got the code, yes.
All right, Mr. Steyer, will come to you to represent Mr. Roberts, not guilty plea is entered. You can sign a $1,000 OR bond. And when did I?
You said it for the 23rd, I think Luke is not here the 23rd, so
I'm not.
if you want to change it, my client's still here, we can do it for me.
July 7th, I think you're both here then.
Yes.
Yes.
Okay, so Christopher Roberts is set for July 7th. And what was the code?
Holly Elkins.
Holly Elkins would be changed to July 7th also. Next hearing will be July 7th for Mr. Roberts, not guilty plea is in.
Thanks.
Thank you. Wait for me in the lobby. I'll talk to you in a couple minutes. Thank you.
He looks.
State of Ohio recalls Caleb Langdon. Caleb Langdon.
Give him the file on that. He didn't take it. Okay, we're not ready for Caleb Langdon. We'll recall him. He is supposed to do a urine screen. Caleb Langdon. That's where he is. He's right there. He's walking. We're not ready for you yet, sir. We'll call you.
State of Ohio versus recalls Dylan Heidel. Case number CRA 22473, CRC 222096, A and B.
I know. That's another thing.
I gotta say though, man, that NDA and all that shit, I don't do that, man. That's crazy.
Taylor, did you get to talk to Mr. Hyden yet? He's right here. I didn't think so.
I have not got to talk to him.
All right, let's, here's the urine screen.
I can take you today. Can we get an ankle monitor possibly? Maybe?
Yeah?
We'll take yours today.
Okay. Yeah. Well, you probably need to talk with him. So.
Yeah, more than likely.
Let's let you talk with him and we'll recall. We'll recall Mr. Hyden.
Thank you, Your Honor.
Stable versus Keon Gage and Naaman Cox, have they reported from jail as yet?
Mr. Gage has reported, Mr. Cox has not.
All right, so I'll mark Mr. Gage's report, and we'll put Mr. Cox aside and recall later in the document. So he did report, and Cox is not reported yet.
State of Ohio versus April Combs.
Ma'am, are you April Combs?
Yes, sir.
Can you hear me okay, ma'am?
Yes, sir.
Okay, I can hear you well. I'm Judge Capper. This is your arraignment hearing. You are appearing in the courtroom by teleconference. So your image and your audio is all being recorded. Whatever you say is going on the record. You have a right to remain silent. You don't have to say anything. But if you choose to make statements, what you say is being recorded. And if you admit something against your case, it could be used against you. You understand that?
Yes, sir.
You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to have bail, to make the state prove any charge beyond a reasonable doubt. You understand those rights?
Yes, sir.
Your charge is domestic violence. It's case number 23346, and it alleges June the 6th in Rome Township, you knowingly caused or tried to cause physical harm to Valerie Walters, and that Valerie is either a member of your household or a member of your family. So that's why it's a domestic violence charge. It carries a maximum penalty of 6 months in jail and $1,000 fine is the maximum penalty. Do you understand the charge filed against you?
Yes, sir.
Do you have any questions before you enter a plea?
No, sir.
How do you wish to plead to this charge?
Not guilty.
You want a lawyer appointed to represent you?
Yes, sir.
Do you have any income right now?
No, sir.
You have no income at all?
No, sir.
All right, Mr. Smith, I'll appoint you to represent Ms. Combs. I have a County Road 88 address for you, Ms. Combs, is that correct?
Yes, sir.
Do you reside with Valerie Walters, or is she in a different household than you?
With her and,
Okay, so, well, I was going to order you to stay away, so that's going to be a problem because you live under the same roof?
No, I can stay away, that's no problem.
You got another place to go to other than where she lives?
Yes, sir.
State's asking for a protection order, I'm assuming.
We are, and we're also asking for at least a discussion about perhaps substance abuse intervention. The alleged victim indicates that that's the basis for the problem that occurred, and it's her daughter. She's very concerned about her mother, and she says this is not the first time that there's been an incident like this, and so I don't know why Ms. Combs has been in jail. This alleged to have happened on June the 6th, 3 days ago. What kind of a bond was placed on her originally?
I don't know.
I would ask bond be admitted to an OR bond with an assessment, and if she's going to go to a different residence.
Where will you be living, ma'am? If you're not going to live with Valerie, where are you going to live?
I'm with my cousin.
Your cousin?
Yes, sir.
Name of your cousin?
Pam.
What's the name of your cousin?
Sherry.
Sherry what?
Again,
Sherry Dement. Where does Sherry live?
I don't know the name of the road. I
Well,
think it's on the side or something.
okay, in the Rome Township then.
Sherry
I'm pretty sure.
Sherry Dement's here.
Okay. All right, she's here in court, and you're okay with her living with you, ma'am?
Yes, as long as she obeys by the rules.
I didn't hear the last thing you said.
I said, as long as she obeys by the rules.
Okay, Sherry's here, and she says she's okay with you staying with her, but you're going to have to abide by her rules. Do you agree maybe she needs to get an assessment for some substance use issues? Okay, so I'm going to make that a condition of your bond. How do you pay for medical services, Ms. Combs? Do you have a medical card?
Yes, sir.
Okay. Are we talking about alcohol or other, mostly alcohol? I'm going to refer you then to, OVP has a clinic in Procedural. There where the Kroger, right across from Kroger. They'll do an assessment and set up some treatment protocol for her. So I want her to go there and get this looked into. That's going to be a condition to your bond. You got to go to OVP and be assessed for treatment, and then come back.
Next 5 Fridays, Judge, your choice
23rd.
would work. In April, could I get a phone number for you so I can call you when you get out?
I don't know my cell phone number right now.
How about
Yeah.
get in touch with you?
304
963
963
0980.
980. Your name was Sherry?
Sherry Dement.
Sherry DeMint, okay. Thank you.
All right, so June 23rd, I'm going to let you out of jail on a signature bond, which means you're just promising, you'll sign a piece of paper that says you promise to come to court when you're ordered to, or you'll pay a $1,000 penalty for not showing up and you get a warrant. So June 23rd, which is 2 weeks from today, Ms. Combs, you've got to be in court at Chesapeake. And Sherry knows where that is because she's here today. So that'll be a pretrial at 10 a.m. Before then, and don't wait till June 22nd to go to OVP. I want you to go there right away. Next week, first of next week, you get in there, get an assessment, and start whatever they say you need to do as far as treatment goes. Okay? So you'll get out of jail today. You're welcome.
State of Ohio versus Todd Daniels. Case number CRB 23344. Sebastian Evans is on that.
Okay, sir, are you Todd Daniels? Can you hear me?
Sorry?
Are you Todd Daniels?
Yes, sir. Yes, sir.
I'm Judge Capper at Orange County Municipal Court in Chesapeake, and this is your arraignment hearing. What you say and your image is all being recorded now, so you don't have to say anything. If you choose to make statements, it's on the record, it could be used against you. You have the right to have an attorney, to have one appointed, if you can't afford one, to have bail, and to make the state prove any charge beyond a reasonable doubt. Do you understand those rights? You have a domestic violence charge filed against you alleging that at Perry Township on June the 8th, you knowingly caused or tried to cause physical harm to Michelle Anderson, and that she's either a member of your family or a member of your household. That's a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand this charge?
Yes, sir. I didn't do any physical harm to her, though.
Okay, I'll take that as a not guilty plea. Do you want to have a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
I have not been working. I just had a hospital double pneumonia, and I have blood clot in my lung, which I haven't seen the nurse since I've been in here. And I have not had medication since I've been in here.
So,
No,
you can't afford a lawyer.
No, sir.
Mr. Morford, I'll appoint you. Todd Daniels, domestic violence, Proctorville address. Oh, you live in South Point?
I did, I suppose I don't anymore.
Well, I've got an address of 218 Township Road, 1159 Proctorville. Is that wrong?
That's not right.
What is your correct address?
239, Township Road 1186, Ohio.
Do you have a phone number?
740-307-2541.
Repeat those last four numbers.
2541.
307-2541. Is that correct?
Yes, sir.
Okay.
Yes, sir.
And you have a place to live other than with Michelle Anderson?
Yeah, I could probably find a friend to stay with.
So the state's asking for protection?
Yes, Your Honor.
I'm going to order that you not go around Michelle, contact her. You can't go back and live with her. You're going to have to go live someplace else.
All right, how do I get all my belongings? I have a cell phone there, and I have all my doctor's appointments. I have blood clots on the lung. And I have doctor's appointments in hematology. I have several doctor's appointments coming up.
Is Michelle,
Medication is also.
is Michelle Anderson here today? Michelle Anderson.
Medication is also.
Sir, just be quiet for a minute. Michelle Anderson. Michelle Anderson, she is not here. Okay, well, you're ordered to stay away from her. If you've got a third party that can go to her and get your stuff, that's okay. But no breach of the peace, you can't go around her, you can't contact her. So with this pending, why don't we set it pretty quickly for a hearing to get, and the state can get in touch with her and try to work some of this out. So let's set it next Friday, the 16th. Are you available, Mr. Morford?
I am, Judge.
Okay, I'm setting your next hearing for 1 week from today, June 16th at 10 o'clock at the court in Chesapeake. Do you know where that is, sir?
At where?
The Lawrence County Municipal Court in Chesapeake. Do you know where that is?
Yes, sir.
Okay, you have to be here next Friday, 10 a.m. I'm letting you out on a signature bond of $1,000 with an order that you not go around Michelle, contact her, or post stuff about her.
I don't have any money, so what do I just have to stay in here till next Friday?
Would you rather stay in the jail than, no, I didn't, I gave you a signature bond.
Oh, I thought that, yeah, I heard $1,000, I'm sorry, I thought that meant I needed $1,000.
You're signing an IOU for $1,000 to the court that basically says you have to pay $1,000 if you don't show up. As long as you show up, you don't have to post the money.
Okay, all right, sorry, I didn't understand that.
Okay. I thought you were saying you liked Lawrence County Jail Hotel. You just wanted to stay there.
I mean, I would if they gave me medication, probably, because not with my clot on the lung, I can't get medication, no, thank you.
Okay. You're going to get out today then. You're not going to be able to stay at the jail.
All right.
They're going to kick you out here shortly.
Yeah.
But you got to be in court next Friday at 10 o'clock. Do you have anything else, Mr. Morford?
Just stay away from the victim, the alleged victim, Mr. Daniels. No contact.
There's no possible way to get anything from that house till next Friday.
I think I told you how you have to do it.
Sorry, I'm just a little worried about having a blood clot.
Well, I understand, but I don't have a magic wand, but I don't want there to be another incident. So you have to stay away from her. If you can get a third party to go get your stuff, that's fine, but they can't breach the peace. And if she doesn't turn it over to them, you got to wait and come back to court.
All right, and when I come to court, then I'll be able to go, you'll give me an order that I can go get myself.
I didn't say that, did I? It'll be one of the things we will discuss at the next hearing.
Okay. You didn't say, that's why I asked, I'm so sorry.
Yeah, I didn't say that, so, but it'll be one of the topics for discussion. We'll try to work that out. If it doesn't happen before now on next Friday, hopefully the prosecutor will be in touch with Michelle and we'll have a solution for that issue.
Okay, thank you, I just didn't know how it worked, I'm sorry.
I understand.
State of Ohio versus Sebastian N. Evans, case number CRB 23349 A and B, and Travis Savage is on deck.
Sebastian Evans. Sir, are you Sebastian Evans? I'm Judge Capper at Lawrence County Municipal Court. You've got 2 domestic violence charges filed. I'm going to go over those with you. First, I'm going to go over your rights. You have the right to remain silent. You don't have to make statements. If you do make statements, what you say is on the record. It can be used against you. You have a right to have an attorney, have one appointed if you can't afford one, to have bail, and to make the state prove any charge beyond a reasonable doubt. Do you understand those rights?
Yes, sir.
You've got 2 charges. The first one, 349A, alleges that on June 8th of this year in Perry Township, you knowingly caused or tried to cause physical harm to a person with the initial ZW, which usually means that they're a minor, and that this ZW is either a member of your family or a member of your household. So that carries a maximum penalty of 6 months in jail, $1,000 fine. 349B alleges that you caused or tried to cause physical harm to Savannah Wingard, and that she's either a member of your family or household. Also a domestic violence charge, same possible penalty as the other charge. Do you understand these charges?
I do. Your Honor, when when the responding officer showed up, I started explaining my side of the story to them, basically handcuffs, putting me in the car, they didn't give me a chance to talk to them. To tell them my half of the story. But I didn't put my hands on anybody. She was hitting me, and then when I told her I was leaving, she called the police on me. She told me that she was going to police that I hit her and that she wants me to get locked up and this and that. And her mom has been her mom has been trying to get me locked up for a couple months now because she just can't stand me. I don't know what her problem is with me, but she's mad because her daughter moved to Tennessee with me. And then we ended up moving back here, and ever since we moved back here, it's just been chaotic. I don't know what else to do, Your Honor.
Okay. I'm going to take that as a very long not guilty plea. So I'm entering a not guilty plea for you. Do you want a lawyer appointed?
Yes.
Do you have a job?
I do.
Where do you work?
I work at Thoroughbred. I make $10 an hour.
Okay, you're out.
Every 2 weeks.
And are you working 40 hours a week or how many hours a week?
35.
Okay,
I'm just doing shop though.
You're eligible for court-appointed counsel. Is Mr. Steyer still here? Yes. Okay, I'll see Mr. Steyer. I think we're back. All right, I'm appointing Mr. Steyer to represent you.
Okay.
He's in the courtroom. He's heard. He loves it when his clients make very long explanations as to the facts.
I'm sorry.
He heard all that. You're not a lawyer, but so you do. There is a Fifth Amendment for a reason. So the not guilty plea is entered for you, and you've got a court-appointed counsel now. We're going to talk about bond and when to come back to court. Protection order too.
We're going to ask for a protection order. We have one prepared.
Okay. Do you have a place to live other than at the residence where ZW and
Yes, Your Honor, I do.
Savannah are living?
Yes, Your Honor, I do.
And where would that be?
My job that I can stay at the warehouse for as long as I need until I get, my back license.
Where's that located?
Thoroughbred, it's in, Ashland, Kentucky. And then, he said it'll take me my full case and everything to get this all handled. Make sure everything's paid to the Thoroughbred.
Mr. Hill?
He's going to stay at a construction company? I mean,
Yes, sir, I'm a roofer.
okay. As long as he's not around the complaining parties.
Okay, so I'm gonna let you out of jail on the condition that you not go around either ZW or is that Savannah, her mother?
No, Savannah is my fiance, well, my ex-fiance now.
And ZW is a child?
Is my son, my 6-month-old son.
Okay. All right, well, you have to stay away from them. This is just temporary. We'll reassess everything. The main thing is I don't want there to be... Sir. Don't interrupt me. The main thing is, not all this other stuff you're thinking about. The main thing for the court, and this is what counts, I don't want there to be another incident alleged. So that's why you gotta stay away from her. We're gonna have a cooling off period. You're gonna go around her, your son. We'll get back in court and some of those issues will work out. I'm sure you'll get to have visitation at some point, but not right away. So.
Your Honor, I'm assuming Monday would be too soon to attempt anything. The next two court dates I'm here are going to be the 16th and the 30th. If one of those days would fit the court's calendar, I think getting back as soon as we're practically able would be helpful on this.
All right, so next Friday, June the 16th is going to be your next hearing. And that's going to be, where are you from originally?
My parents live in Indiana, but I'm not from there. I don't live there anymore. I live out here.
Well, that was going to be my point. Do you know where the court is located?
Oh, yeah, for Ironton, yes, I do.
No.
It's not Ironton. And they threw you a curveball there. It's not Ironton.
Do you know where the flea market in Chesapeake is?
Yes, sir.
This is across the street.
Okay.
County Road 1. It's on County Road 1. So you need to be here next Friday at 10 o'clock.
Thank goodness there's a flea market across the street from this place.
That wouldn't have been my first reference for him, but.
I think it's the one most people know.
Okay.
Seems the safest
He looks
reference.
a little young to be a flea marketer yet. But.
Do you have a phone number that you're going to have access to, sir?
Yes, if they found my phone, I don't know.
What's your phone number, sir? You went a little way too fast for me. Say again slowly.
219?
219?
Yes, sir.
Okay.
216?
Okay.
0392.
Okay, I'll send you a text. Is that a cell phone? I'll send you a text message so you can get a hold of me once you get out, okay?
All right, thank you.
Thank you.
Okay, so I'm going to let you sign a signature bond of $1,000 with a protection order to stay away from Savannah and ZW. Be back in court.
$1,000 to get out?
No, you'll signature bond.
Signature bond. So you're just promising that you'll come to court, or then you'll have to pay $1,000 if you don't show up, and you get after you get arrested. So next hearing, June 16th, 1 week from today, 10 o'clock in Chesapeake. Not Ironton, Chesapeake. Don't go to the court in Ironton. You'll be at the wrong place.
Thank you.
That's all.
Thank you. Am I all done?
You're done.
Thank you.
State of Ohio versus Travis Salyers, case number CRA 22418, CRB 22420, CRA 22791. Damian Fox is on deck there at Orange County Jail. And, Your Honor, we have Evan J. Holmes on recall.
Okay.
Cooper is requesting this recall. Case number TRC 22463.
Your Honor, Mr. Holmes did show up today. He didn't finish his community service, so I believe this case will be completed.
All right, I'll mark Evan Holmes as completed.
He did turn his community service in.
And no further review hearings necessary then. All right, Travis Salyers. looks like it was Monday when we had a little problem with Mr. Sayers and his attitude.
We did. Mr. Sayers, we tried to find another placement for Mr. Sayers, just so that he could stay in treatment. He has done exceptionally well up to this point, so I don't want to cast a shadow on that. But he did make the decision that he didn't want treatment, and he left ASA. Majors picked him up and arrested him, placed him in jail. His fiance, I believe, reached out to me on Wednesday and asked if we would take him back, and we are in agreement that we would if the court would allow it, but he would have to start and kind of refresh himself behaviorally.
And this really started before Monday. Didn't he have an incident, or was it that morning he had a problem with the...
It was that morning. Everything kind of happened that morning. It was from the staff threatening them, and then another client, and then...
Well, how did that work out for you, Mr. Sayers? And whose fault was that?
The worst mistake, it was mine, and it's the worst mistake I could have made ever.
So what are you asking the court to do now?
If all possible, I can go back to treatment.
And you're going to accept whatever they set up for you as far as if you have to do some refresher or have to start some things over again?
Taylor, I'm very sorry. Catherine, I'm very sorry for having to come to you this way.
Yeah, you...
I promised I could get it right.
Okay, well, what's the state's position? Yeah, you've got 2 felonies pending against you, and this was a case where we agreed to keep it here and you not go to the felony court, not get indicted by the grand jury, which is a really big deal. That's a big, big deal not to have a felony. And then you take the risk that it's going to happen and you're going to go to prison over this?
Yeah, I wasn't thinking clearly. It's apparently that I still need treatment.
What's the state's position?
If it weren't for the fact that somebody like Taylor's up here saying that they'll take him back after what happened, we'd think he needed to go to the common police court and face potentially going to prison. But since they want to have him back, they're willing to take him back, and he sounds like he's showing some remorse today. Maybe a few days in jail made him think more clearly. And we don't have a problem with him going back as long as there's a time waiver. Hopefully he'll not have any more of these.
Mr. Morgan.
So waived, and I'd like to see Travis back in treatment, but Travis, do you understand the precarious situation you put yourself in? Judge Capper could very easily just say, send this down to Ironton and not fool with you. I mean, he's a man of chances, but you have to earn them. And you have to show him that you are serious about it. And leaving against staff advice and the things that have happened recently aren't painting a good picture to him or to the prosecutor.
Things haven't been working out all the way.
And I don't mean to be standing here lecturing you, but I want you to understand the legal position you put yourself in. It is not a good one, let's put it that way. In your future, right now, I think depends on your sincerity and convincing Judge Capper and Mr. Heald that you are serious about treatment. And if Bethesda takes you back, you may be started back earlier some in your treatment than where you have progressed. Are you willing to do what is asked of you at treatment?
Yes.
And not leave again?
Yes.
Okay, we're going to try it again, but I'll just put this on the record. This is the last chance. If there's any more incidents, you're going to common police court. And you feel lucky because you got a 50-50 chance, or maybe more with the history here, that you'll go to prison. You go to common police. Okay, you've got to control your impulses. You get impulsive, you get angry, and then you just act out and you do damaging stuff to yourself and other people around you. You've got to get a handle on that.
I understand.
Okay, I'll order him released to be picked up by Bethesda today, start treatment over, and I'll change his next hearing. I want to see him sooner since he's starting over. Let's make it June 30th, that's 3 weeks. So I'll see you back in 3 weeks and get a report as to how you're doing. Of course, Taylor texts me. If something goes wrong, I'll hear about it today. If yours have another outburst in the car, she'll text me today, and I'll know about it today, and I'll take some action. I mean, you didn't get very far, did you?
No.
You didn't get away very far before you got picked up. So June 30th is your next hearing, 10 o'clock. Good luck. And one of the reasons I'm doing this is because you've done so well before. You were really doing well. So I want to acknowledge that until you had this hiccup or whatever it was you had. Bad moon rising, something happened. Don't let it happen again.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
Thank you, Taylor. Thank you, Chance.
You're welcome.
State of Ohio versus Damian Fox, case number CRB 23307 A and B. And Christy Starcher is on deck.
All right, Damian Fox is here, and Mr. Morford, this is actually your case. My record shows he failed to appear for a pretrial on May 22nd of this year, and that's on the domestic violence. 2 counts of domestic violence.
What date, May 23rd?
May 22nd.
What's that?
May 22nd, failed to appear. And he had an OR bond then with an order to get a mental health evaluation. And I don't see that he didn't show up, and no mental health evaluation reports filed with the court.
I have all the information I read the mental health hospital and asked they're used to some giving my medication and stuff here. I couldn't show up there. I went from here to the post to Hammond. Hammond picked up here to the county jail. And I was told that the county jail dropped the case, and I was over there and asked the about it. And then I went to see my brother, and my brother was like, this is not on the computer no more, but I know we dropped because we showed you it was next time. I don't even know if it was the next time, because it's a verbal altercation between me and my nephew. And my nephew, he had
It might be a good idea for you not to go into the facts, sir.
What's the state's position on bond now?
Well, Your Honor, I believe that there may be a parole holder on it.
Probably so.
And I don't know whether it's just because of these charges or whether there are other things.
there is
So,
the parole violation, if you get charged with extortion or domestic violence, they automatically catch you with that. Like now, and there's a line around over there. It should be just domestic violence abuse, or verbal abuse. If there's any way this drop down to not domestic violence, I'll accept it today, do my time today, whatever you want me to do. Because I'm gonna check myself into a self-living house. I can get in the jail down here, I'm still wonderful, but it's not, I have resources to reach out, get in the jail. I would love to get out there and check myself. We had that shoot that I do. Because my parole officer, he's not gonna let me out because I got charged with domestic violence. I was looking, he got 2 now, and they the ambulance came and got me here. I was in locked up, I couldn't make it, I had very good state now, I was in there on the 26th. There's no way I could make it. And then they told my family, came here, that it was all coming out. And then I guess when I talked to the parole officer, the day before yesterday, I was in the hospital, I left the hospital. he has to charge him because of a violent crime. But if it wasn't a violent crime, it was just two family members working, and I'm going to get help about it. Because every time I use drugs, I guess they don't like you. Nobody touched each other.
Again, Mr. Fox, don't go into the facts, please. This is much more for your lawyer, and I'm advising you not to talk about the facts of this case. Who is your PO, sir?
His name is Justin something. I'm not sure what his last name is. He's the only one that knows that Justin kind of stocky little guy.
Is he in the Ironton City Center?
Preston. Yes, it's Justin Preston.
Okay.
He's in Ironton, right about him. Justin Preston.
Does he have a hold on you?
Yes, he has a holder on me over this, and that's what I'm saying. I can't get this stuff to go through. We had, I take care of that. Or I don't know, it's not what we have on the house. Or we have not something my problems, so like I have more problems than that. I know you said I'm saying that.
My office is right across the hallway from Officer Preston's, and I will speak to him this afternoon after Judge Capper makes his decisions that he has to make this morning.
What's the state's position on bond for Mr. Fox going forward?
Well, I think Mr. Fox indicated that he understands that he has some issues that need to be addressed with maybe a treatment program of some sort. The individuals that are the victims in this matter want the same thing. So I don't know whether it could be arranged for him to be released to a program or not, but if it was...
As long as these charges are pending, I think he's going to have a holder from adult probation, is my understanding.
And then the question is, will they agree to lift it if he's released, maybe with the electronic monitoring, that kind of thing, which
Why don't
maybe...
we put it back on the docket for Monday? Mr. Morford can talk to his parole officer this afternoon, and maybe we'll have more information, but I don't see any way we can get it today.
No, if they're in, Judge.
If they're in.
To catch the parole officers in. But if not today, I would try early before his case gets called Monday morning.
Okay, I'll continue Mr. Fox's case. I'll just keep the bond as is, but it sounds like he's not going anywhere anyway because of the issues with adult probation. So next hearing is then the 12th, June 12th.
Mr. Fox, I will speak with your parole officer and see if he would agree to releasing his holder to the extent if you would be admitted to inpatient treatment or whatever kind of treatment you might be assessed for. And I'll be in touch and I'll let you know what he's got to say.
Next hearing is Monday morning, 10 o'clock.
Thank you, Judge.
You're welcome.
State of Ohio versus Christie Starcher, case number CRB 23302 A and B. William K. Elkins is on deck.
Ma'am, are you Christy Starcher? Can you hear me okay, ma'am? Okay, can you move your microphone a little closer because I'm not hearing you very well. Okay. Yes, that's better. I'm Judge Capper at Lawrence County Municipal Court. This is your arraignment hearing. You have a domestic violence charge filed against you. Maybe two. I got a 302A and B case number. 302A alleges that at Rome Township, May 3rd, 2023, you knowingly caused or tried to cause physical harm to Marcus Starcher, and that Marcus is a member of your family or household. Maximum penalty for this is 6 months in jail, $1,000 fine. The B case, 302B, alleges May 3rd, Rome Township, you not only caused Matthew Starcher to believe you would cause imminent physical harm to him. That's a 4th degree misdemeanor, maximum penalty, 30 days in jail, $250 fine. Do you understand the 2 charges? Do you understand? Well, I didn't explain your rights, I don't think. You have a right to remain silent. You don't have to make statements. If you do make statements, they're on the record. They can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bond and to make the state prove charges beyond a reasonable doubt. Do you understand these things?
Yes, sir.
Do you have any questions before you enter a plea to these charges?
Yes, sir.
What plea do you wish to enter? Do you want a lawyer appointed to represent you?
No, currently have a divorce lawyer, which is Matthew Anderson. And I'm going to contact them and see if they can take care of it with it.
I guess we're going to need a special prosecutor.
Sounds like it.
Okay. Well, you can talk with them, but they're not going to be able to represent you because they are also the prosecuting attorneys in this county. So they won't be able to prosecute you or defend you. So do you have a job? Do you have income?
Yeah, I'm a nurse.
Okay. Well, you're probably not eligible for a court-appointed lawyer then. So you're going to need to make arrangements to get a lawyer. What's the state's position on bond?
We're going to ask for a protection order, but we're not opposed to an OR bond as long as we know sounds like she has another place that she's been living.
Do you have a place where you can go to live other than with Marcus and Matthew Starcher?
I left our home. Matt and I own that home. He's who I'm divorcing. And I left that home in January, give or take.
Okay. So you have a place other than with him or Marcus to stay?
Yes, I live at 6 Mohawk Trail in Greenwood now.
Okay. I'm going to let you out on a signature bond. So what that means is you're going to sign a piece of paper that says, I promise to come to court as ordered, and if I don't show up, then I'll be ordered to pay $1,000 plus I get a warrant for not showing up. So just come to court, you don't have to post any money. Now, how much time do you think you need to make arrangements to get a lawyer to represent you?
I don't know who to get, but I'll figure it out, now.
Let's make it 3 weeks. Is that too long? You want it resolved? Is there pressing issues you'd like to come back to court on before then?
No, that's fine.
Okay, so I'm going to make it 3 weeks. That's the 30th of June. That'll be your next hearing.
Okay.
You know where the court is in Chesapeake?
Yes, sir.
Okay, that's where you're going to come for your hearing. June 30th, the last Friday in June at 10 o'clock. I'm letting you sign a $1,000 signature bond. We're going to send down a protection order for you not to go around or contact Matthew or Marcus and to stay away from them. Do you understand that?
Okay, then that's a problem because Matt's here with my mom. He went and got my car because I was on the phone with him when I got pulled over because he said that he didn't do this, he doesn't know anything about it. So, he's here with my mom. He went and got my car off of the side of 52.
Okay, we're gonna have the prosecutor. Do you have contact information? Do you have the phone number for? And it's Matt that has the car.
Well, they're here, they brought the car here, they're waiting on me to finish to see what was gonna happen.
Oh, okay. Well, is there a cell number where he can be reached? Maybe he doesn't want a protection order.
304-654-3599.
Okay, we're gonna try to get a hold of him and then we'll recall you back up and that may change. I may not do the protection order if they say they don't want one, if he says he doesn't want one.
And we also have the special prosecutor issue. If she has hired, did she say Mac Anderson?
I think she said both. You said you've hired the Anderson?
I hired Mac, but Mac had to have surgery or something, so my case had to be transferred over to Brigham.
Okay, so.
I just met with Brigham on Tuesday of last week.
Okay, so I'm going to appoint a special prosecutor to handle your case. Well, that's really not much of a concern to you, but I'll have to appoint a special prosecutor. which will be, my choice will be Ryan Ashworth if he'll take it. So I have to contact him. All right, ma'am, we'll recall you after the prosecutor's going to try to get a hold of Matthew and see what the situation is on your car and bond, and then we'll have you back up and finalize things.
Okay, thank you.
So from the jail, you can keep her out. It shouldn't take very long to get that information.
State of Ohio versus William K. Elkins Jr., case number CRB 23347, and Barbara Lawson is on deck.
All right, I'm looking for William Elkins Jr. William Elkins Jr. at the jail.
You're walking down the hallway, yes, you're right here.
Thank you. All right, sir, are you William K. Elkins Jr.?
Third, actually.
Okay.
Nobody wants third.
Date of birth, March 26th?
Yes, sir.
Now, I've got a note here, something about a social security number being a discrepancy. What I've got, last four digits, 5786, is that wrong?
Number I can answer, my father has had that information entire my life.
Okay.
I never had a chance to learn it.
All right, well, we'll proceed. This is your arraignment hearing. You're appearing in the court on a television monitor. It's all being recorded. So what you say is on the record. If you admit something about your case that's damaging that the state wants to use, they can't use it. So you don't have to say anything. You can remain silent if you wish. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bond and to make the state prove charges beyond a reasonable doubt. Do you understand those things?
Yes, sir.
The charge is domestic violence. It alleges that on June the 8th in Union Township, you knowingly caused or tried to cause physical harm to William K. Elkins Sr., and that he's either a member of your family or a member of your household. So that's domestic violence charge, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
And you understand your rights? Any questions before you enter a plea?
No.
What plea do you wish to enter?
Not guilty.
You want a lawyer appointed to represent you?
Yes, sir.
Do you have a job?
No, sir.
You have no income right now?
No, sir. I've been able to take care of my father for the past 6 or 7 months now.
I'll appoint Mr. Morford to represent you. Enter a not guilty plea for you. And you live in Chesapeake, Township Road 278?
Yes, sir.
Are you under the same roof with your father?
Yes, sir.
Is there a place you can go to stay away from him?
He's not requesting a protection order.
Okay, well, forget that. he doesn't want a protection order, so I don't have to worry about that. So you're not prohibited from going back to say, to live with him. So I'm going to let you sign a signature bond of $1,000. And William Elkins, the third, he says. It's marked as junior, but he says it's the third.
Your Honor, we'd like a condition placed on the bond, and that is that Mr. Elkins would be assessed for some mental health counseling. That's according to his father and his assessment of the situation, that he could use that kind of counseling.
Has that ever happened before, Mr. Elkins, that you had mental health assessment or treatment?
Whenever I was younger.
Where did you go then?
Injuries.
Well, how did you like, is that a place you would want to go back to, or you want to try something different?
If the court sees it necessary, yes, sir.
You're okay with Mended Reeds? If you're comfortable with them, I'll let you go back there. You live in Chesapeake, there's now places closer. There's a place in Chesapeake that's fairly new, Path.
If they have any available slots open, I would be willing to visit as well.
Okay, well, let's try Path. It's, do you know where the Chesapeake Plaza is? And it's old, it was City National Bank, I believe, that was in there. They're in that building now.
Okay. Okay.
Across from the Dairy Bar in Chesapeake.
Yes,
okay, they've been working with the court, so you just tell them that you've been referred there as a part of your bond. They'll do an assessment. If they think you need some counseling, they'll set it up. If not, then they'll issue a letter to the court to that effect. So,
what did you say was the place again?
Path, P-A-T-H.
Thank you.
And I think you can go walk in, but I'm sure they have a presence online, so if you want to call them, you can look up their phone number. I don't have it here, but I think you can walk in and get an assessment. But anyway, I want you to do that before you come back to court the next time, and let's see about when that would be. June 30th?
You said June 30th, sir?
Yes, I'm looking at your lawyer to see if that's a date that works for him.
The 16th and 10th of July, and that's good for you.
He's already here June 30th, so let's do that.
Okay.
Yes, June 30th, that's 3 weeks from today. You gotta come to court in Chesapeake at 10 o'clock. Do you have a cell phone or a way Mr. Morford can get in touch with you?
My cell phone is currently on.
But you'll be getting it, right? Or you mean it's off permanently?
It's off, like there's no cell service to it.
Is there another number where you can be reached?
The only one I would take with me is my father's, as far as the most reliable. You could possibly try to get me on Facebook, it's about the only thing I can think of, or offhand. If not, I can give them my Facebook name, you could try to text me on there, and you get started, communication started.
What is yours? Screen name on Facebook, sir?
Is William Wicked Elkins, Wicked with 2 Ks.
William?
It's just Wicked Elkins, Wicked has 2 Ks in it. That's just a name that my friends gave me. I asked boss and passed stuff.
I'm not catching it. I've got William and...
Wicked.
Wicked.
With 2 Ks.
Okay. W-I...
K-K-E-D.
K-K...
E-D.
E-N...
E-D.
E-D? Okay. Wicked. Okay.
All right, June 30th is your next hearing, 10 o'clock. You can reach Mr. Morford's office too. Warren Morford, he's in the city building in Ironton. So if you want to look him up on the internet, you can find his office number there.
I'm on Facebook as well.
And he's on Facebook.
I don't think I do.
You said it, Ward, Warford?
Morford.
Ward. What did you say, sir?
M-O-R-F-O-R-D.
2 Ds. Okay.
Morning, Mr. Ashworth. Thank you, Mr. Ashworth. We'll be in touch.
State of Ohio versus Barbara R. Lawson, case number CRV 22709.
All right, this is Mr. Morford's case, Barbara Lawson, and she's at the jail. Was arrested on a failure to appear.
I didn't have a problem. Failure to appear, I believe, probably, Judge.
Yes, 22709 is the case number. She had a hearing on February 24th. The case was going to be dismissed, and if she paid costs and completed counseling, she didn't appear, and she didn't pay costs. And I got a letter from Riverside saying that she had not completed treatment either. So, Ms. Lawson is in jail now on the warrant. Do you want to call down and talk with her? I'm sure you haven't had a chance to discuss this with her.
Not yet, Judge.
All right, Ms. Lawson, I'm going to let your lawyer call and talk to you, and then we'll recall it after that's happened and decide how we're going to go forward.
Butch, can you find out how long she's been in jail?
Yes, sir. Judge, may I have your file on that?
You may.
Thank you.
State of Ohio recalls Christy Starcher, Lawrence County Jail.
It doesn't matter what the actual name is.
Okay, that's... No, I don't think it's ready, but I'll tell Mr. Ashworth, would you be willing to undertake a new special prosecutor role? Or do you have
Absolutely. 5 years, Your Honor, absolutely.
Okay, so this is the defendant, Christy Starcher, and we have contact with Matthew Starcher to prosecute any information?
We made contact with her. We don't want a protection.
Your Honor, I was actually able to make contact with both Matthew and Marcus Starcher, and Marcus is Ms. Starcher's biological son. He is the other victim, and neither of them are interested in a protection order.
Okay, so good news. Ms. Starcher, neither of the complaining parties in the cases want a protection order. So that relieves us of that obligation. So I'm going to let you sign a $1,000 OR bond. And Mr. Ashworth, I know you're here for another case, but it came up earlier under the arraignment. Ms. Starcher is being represented in a divorce involving one of the victims, and Mr. Anderson, Brigham Anderson, is her lawyer in that divorce case. So they're going to be precluded from prosecuting, and Ms. Starcher will have to get defense counsel other than Mr. Anderson. So I tentatively set this for June 30th for a pretrial, but we can do a different date depending on what's good for your schedule.
I am on vacation on the 30th after trying a case against Kenny Hicks, so I appreciate Your Honor if
You'll probably need 2 or 3 weeks after that. When would you like to come back? You give me a date and we'll make it work.
Let's try to do the, I don't want to wait too long, let's do the 10th.
July 10th? All right. Ms. Starcher, I'm setting your next hearing for July the 10th at 10 a.m. And you're going to get out here in a few minutes, as soon as we get the paperwork, with just a signature bond, and you don't have to stay away from anybody. But you do need to come back to court on July 10th at 10 o'clock. Do you have any questions of me, ma'am?
No, sir.
And apparently, one of the gentlemen has your car. I think the car is at the jail for you to pick up, I believe. Is that correct?
Yeah, now, what's gonna be my ex-husband is here with my car.
Okay. All right, well, you probably are going to need to get another lawyer to handle this, or at face value, that's what's going to happen. You probably need to talk to Mr. Anderson also about the divorce proceedings. Maybe something could be worked out before July 10th. But as of now, your next hearing here is July the 10th on the criminal charges that have been filed. Any questions, ma'am? And let's set it for, let's make it noon. I think that's more convenient for Mr. Ashworth. We'll make it at noon. It'll be better for you too. And he can appear by teleconference
Okay.
for a pretrial, July 10th. What's the case that you're on today, Mr. Ashworth? Mr. Ashworth, what's the case?
I didn't do I'm here for the corporation, Your Honor.
Okay.
Can I ask one question? I'm sorry. I know I said that I didn't have a question, but may I ask a question?
Go ahead.
If Matt is saying that he didn't press these charges, does he need to come that day?
Well, he needs to talk, you'll need to talk to Mr. Ashworth. Do you have a cell, do you know the cell number for Matthew Starcher?
Yeah, that's one of the numbers I gave you a little ago.
Well, give it to me again, because Mr. Ashworth wasn't in on that conversation. He's going to be the one involved.
304-654-3599.
That's Matthew Starcher.
And I don't know Marcus's, off the top of my head, it's just in my cell phone.
And
Yes.
Matthew Starcher is your estranged husband, and there is a divorce already filed?
The divorce is not filed yet. Like I said, I met with Brigham Tuesday of this past week.
Okay, but it's
It's in
impending.
the process.
It will be filed. Okay.
Yes, it will be filed, it will happen. Because there's a lot more to it, but there's not.
Okay, we don't need to get into that today, so.
I understand.
All right, so that's all, ma'am. Thank you.
We'll send the file to Mr. Ashworth.
Okay, and the prosecutor will send their file to you, Mr. Ashworth.
Thank you, Your Honor.
State of Ohio versus Courtney Riggs, case number CRB 22738.
And that's the case that Mr. Ashworth and Ms. Scott are here on, and I believe Courtney Riggs is also appearing by teleconference for pretrial. So everyone's on the screen now.
Yes, Your Honor, last time we talked, Courtney was ready to submit herself to the Word House for evaluation. I have heard from them. I'm interested to hear what the news is, if anything, and we'll start from there.
So we had a conference with the Word House prior to coming on to the teleconference today, and they were scheduling for an evaluation. I spoke with Ms. Bell. They were unclear about what we were exactly asking for, so I clarified that for court purposes and what they needed to do, and then Ms. Riggs stayed on the line and scheduled that, so she could speak as to when that was scheduled.
They have me scheduled for tomorrow at 11 o'clock.
Mr. Ashworth?
Yeah, can we set this for trial?
Yes? Yeah, it seems rather late to be getting the evaluation done. When do you want to set it for trial?
She's attempted multiple times to talk to them and left multiple messages for them. And today was the first time she actually was able to obtain them on the phone. But remember, we just got that order on May 8th or a couple days thereafter And they were unclear as to exactly what the court was asking for or what the purposes of the order was. So realistically, this is the first opportunity we've had to have to talk to them personally.
Mr. Ashworth?
I don't dispute anything that you said. I do recall from last year, and this was that long ago, that she was, I thought, scheduled to have an evaluation the day after last year. Maybe I'm misremembering that, but nevertheless, it's just one of those things where we've had plenty of time, and it doesn't happen by the time we're involved in the
Okay, let's
She
go,
definitely,
let's go out some, and lawyers and everybody work better off of deadlines. So why don't we go ahead and schedule a trial date, and then we can have a pretrial in between, and then if things look like we don't need a trial to resolve things, we can cancel the trial date. So maybe 6 weeks out for a trial date approximately, and then 3 weeks for another pretrial. And hopefully get a report by then from Word House, I think is the name of the place.
That's fine. Yeah.
So that would be, yes.
Your Honor, since I've never appeared in court for a trial before, what days do you typically set those on and how long do you schedule them for?
Mondays and Fridays, as long as they take.
Okay, and they begin at 9 a.m.?
No, it would, typically we start trials at noon.
At noon, okay, that was my question. I was just unaware of all of those nuances, Your Honor.
Sure. So I'm looking around, doesn't have to be July 21st, but sometime around July 21st, what's council's schedule? What's a good date? Could be a Monday or a Friday.
Well, Your Honor, I was actually just looking at my schedule for another court, and I will tell you, I do not know that I have anything until actually August to be there. I would have to leave at 11 a.m. to be there by noon, and to be there the remainder of the day.
August 5, Your Honor.
Okay. August 4th, August 7th, what works?
I'm on vacation that whole day, afternoon of the 3rd, and I do not return until the 14th.
Okay, August 18th.
18th is fine.
I can miss work activities.
And I have a person custody here that entire day, that day scheduled. Already.
21st, 25th, was over for me, Your Honor.
I'm sorry? 21st?
21st and or the 25th, whatever days work for them is fine for me.
Either of these are fine.
I would not be available. I could do, oh shoot, sorry, let's get to the wrong. As of right now, I have a jury trial scheduled on the 21st, full day hearing in Pike County on the 25th.
28th. August 28th.
I have it held for our domestic relations court as backup day.
Well, we're going to trump that. That's not going to work. You don't have a case scheduled, so we're going to take the 28th.
Correct.
What say you, Mr. Ashford?
Okay.
I will make it work, Your Honor.
Okay, August the 28th for trial at noon.
Oh, 28th, I thought you said the 25th, I'm sorry, 28th. Okay, you keep skipping, my calendar keeps skipping to the wrong month, I'm so sorry. The August 28th, yes. Okay, well, 28th at noon.
Noon for trial, and let's come back then, and you can do this by teleconference. We should be able to get a report the week of July 10th, 14th or 10th.
I would be available at 9 noon either day.
Mr. Ashworth?
And are we talking about July?
Yes.
We just set that up around the 10th,
All right, July 10th at noon by teleconference with a report from Board House.
We'll make that happen, Your Honor.
Thank you.
Yes, and
That'll be at noon on July 10th.
Is that a pre-trial?
That'll be a pretrial with a report. Anything else that we can do to help move this along?
Not that I'm aware of, based on my conversation with the Word House today, Your Honor, they were just confused about what we were actually requesting through that entry. That was clarified by myself with them today, and then I believe that we'll be moving forward expeditiously on this now.
Okay, I'll see you all on July the 10th at noon.
Thank you.
Thank you.
State of Ohio recalls.
Thank you, Ron.
You're welcome.
State of Ohio recalls Barbara R. Lawson at the Lawrence County Jail, case number CRB 22709.
This is Mr. Morford's case, and we're going to take an opportunity to speak with Ms. Lawson.
I have.
All right, she's back on the screen on teleconference. Can you hear me okay, Ms. Lawson? Okay, you're muted on your, I think, your end. Okay, I see you talking.
Okay.
Should be something on the headset that needs to be turned on. Try.
Can you hear me now?
I can, yes, there we go.
Okay.
Mr. Morford.
Judge, I've had a talk with Ms. Lawson. Back earlier part of this year, she was bouncing back and forth between treatment and home. Her husband would beg her to come back home. She'd go back home, then she'd go back to treatment. Her desire is to return to treatment in Portsmouth at a place called the Crisis Center. She has been there before. She was inpatient for about 5 or 6 days before her husband talked her into coming home again. Her dealing with husband and rehab and going back and forth between rehab and home are the reasons she didn't appear before you in February and March of this year, Your Honor. That's also the reason why she hasn't completed her counseling, paid court costs.
I think that's a part of the counseling center, I believe. Is that like a detox or?
It is. It's a, yeah.
I lost my contact person with the counseling center, so.
Yeah, I believe we should do that.
Okay.
We have a Nick Ferrer at the counseling centers.
Okay. All right, let's give this to Mr. Morford and let you call him and see position is, whether they'd be willing to accept Ms. Lawson. Okay, we'll do some calling and call your case back up after Mr. Morford talks to the council.
Okay.
So you're the last one. If you want to, if they'll let you stay there, you can just stay there in the chair. We'll call you back up when we're ready to talk about it.
Okay.
State of Ohio recalls Michael Clay, case number CRB 2010-23, CRB 18-796, CRB 18-251. Michael Clay.
He never did show.
No, Your Honor, and I never received a response from Southern Hope.
That's disappointing. All right, he's got 7 days before warrant issues.
Thank you, Your Honor.
State of Ohio recalls Caleb Langdon, case number CRA 23-23-32, excuse me, CRA 23-233. It's a little confusing. State of Ohio versus Caleb Langdon, case number CRA 23-332, CRB 23-333. Caleb Langdon.
They're looking for him in the parking lot, Your Honor.
State of Ohio versus Dylan Hyden.
And this is Mr. Warford's case.
He's on phone counsel.
Okay, just have to see your lawyer's tied up, so.
State of Ohio versus Naaman Cox. Is Naaman Cox ever shown to report for jail?
Naaman Cox.
He's not here.
Okay, so I'm going to issue a warrant for his arrest. He did not report, so, and we don't need to wait 7 days. There'll be a warrant issued today for failure to appear.
Gene never answers his text. I'm going to say crying emoji.
State of Ohio versus Tyler Wellman, case number TRC 23-316, A and B. Mr. Haslam's case.
All right, this is Mr. Haslam's case set for a motion.
Correct, Your Honor.
Is the state ready to proceed on motion?
Sure, yes.
Lieutenant's ready to proceed?
We are ready, Your Honor.
Okay, what is the issue that we're, at stake here? What are we disputing?
Your Honor, we're disputing the probable cause for the stop specifically as mentioned in the narrative, as well as substantial compliance with the NHTSA field sobriety testing.
All right, the state will go forward with that evidence.
Sure. Now, so you're not making an issue of the breath testing and all of the records and all that business?
That's part of it.
Well, he didn't mention that part. So, yeah, we're prepared to go forward with everything.
So,
Call Trooper Bean, Your Honor. And we're going to need the video as well.
okay. Raise your right hand. Do you swear the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
You may be seated.
Trooper, can you tell the court your name and where you're employed?
Yes, Trooper A.J. Bean of the Ohio State Highway Patrol.
You work out of the Ironton Post
Yes,
located in South Point. Were you on duty on March the 26th of this year at about 25 minutes after midnight?
Yes, sir.
And while you were on patrol, did you have contact with Tyler Wellman?
Yes, sir.
Where were you when you made contact with him?
I initiated a traffic stop for a violation. It took place on State Route 775, and the stop ended up halting on State Route 7.
Is that in Union Township here in Lawrence County?
Yes, sir.
Do you see Tyler Wellman in the courtroom today? And if you do, can you point him out, please?
Yes, sir. He's right there.
Did you make a traffic stop on Mr. Wellman's vehicle?
Yes, sir.
Now, were you in your standard patrol cruiser
Yes,
at that time? Does that have video cameras
Yes.
installed? Were they working at that time?
Yes, sir.
Did you have a body camera also installed and working at that time?
Yes, sir.
So is there a camera that faces forward out of the front of the cruiser?
Yes.
Is it working?
Yes.
All the other cameras working?
Yes, sir.
Is there one that also shows the back seat?
Yes, sir.
Did you make that video available to the prosecutor's office for use?
Yes, sir.
Did you have a chance to look at that video since the time of the stop?
Yes, sir.
You're familiar with what happened?
Yes, sir.
Okay.
I have no idea how to get that.
Mr. Major.
I'm not there.
See here.
Yes.
Mr. Major?
Mr. Major. Mr. Major.
So Trooper, I would like for you to go ahead and describe what happened from the first time you noticed Mr. Wellman's vehicle at the point where you stopped.
Yes, sir. So that evening, the sheriff's office had alerted me to what was reported to be a massive party going on out State Route 775. There's an estimated, I believe, 150 vehicles parked on the side of the roadway. Myself and Trooper White went out there to work the area, see what was going on. Trooper White was working in a location north of that party. I was working in a location south of it, sitting stationary on patrol. At one point it became apparent that the party was ending because there were large strings of cars coming through the area, which is highly irregular for that time of day. And then there was a truck that passed me, right as it passed me, it throttled the engine. It sounded like it accelerated accidentally. It revved the engine and backed off of it. That was really interesting timing to me that would happen right as it was passing me. So I pulled out, tried to catch up with the vehicle. I do, as I'm following the vehicle, I watch several violations take place. It drives on the yellow dividing lines. It's speeding in a 45 zone at a pace speed of 58 miles an hour. A couple of times I paced it. As we approach the intersection of State Route 775 and 7, State Route 7, the truck rolls through a red traffic signal, and it did not use its turn signal as it made that turn. So I initiated that.
You recognize this as the video, beginning of the video of this stop?
I believe so. Yes, March 26th. I see it there.
Is that Mr. Roman's vehicle in front of you there?
Yes, sir.
Stop here for just a second. Did you turn your microphone on?
So when I activate my camera, from the moment that I activate it, backtracks 90 seconds. So for that 90 seconds prior to me activating the camera, there's no audio that takes place because I wasn't on the camera. But it still captures that 90-second video feed. From the moment I activate my camera, the microphone activates as well. So that's why you didn't hear audio for the first 90 seconds.
Now, are you describing what you're seeing now?
Yes, sir.
From here forward?
Yes.
Do you know what you just said there in case it wasn't clear to everybody?
Yes, I was placing the vehicle at that point at 59 miles an hour on 45 zone. And it drove the yellow lines again.
Say that again, please.
And I additionally, before that, said that it drove the yellow lines again.
So how many times? Do you know how many times you'd seen him drive on the yellow line?
I believe I count twice.
What did you say there?
Stay around 7, it's coming up here.
And what do you see at this point?
He's approaching the traffic light that is indicated red. Slow roll through the stop. No, he just turns through.
I'd like for you to summarize all the things that you saw from the beginning up to the stop that led you to the decision to stop.
2 left of center violations, speeding violation of 45 zone, failure to come to a complete stop for traffic signal indicated red, and failure to turn signal.
Trooper, how long have you been working as a trooper?
My initial start date was January 20th, 2020.
So you've been at it for quite a while now.
It's over 3 years.
And you work on the road as a patrolman on the road primarily as your work, right?
Yes, sir.
When you see that number of violations over that distance, which is a relatively short distance, is that an indicator to you that somebody might be impaired?
The violations in and of themselves, you can make an argument for anything, but knowing that he was coming from the location of a lunch party, having that odd, acceleration or a throttling sequence as he passed me, I even notated a braking sequence. He's going through a curve. It was very low in the curvature, so braking seemed odd there. Maybe speed. You've got left of center violations. You've got several violations going on. So you're at least wondering about impairment. Not saying it is, but it's in your mind. You're wondering about it.
Now that video, whether it's as clear as your eyesight would have seen it at that time, but is it an accurate representation of what you witnessed?
For that camera's capabilities, yes.
Now, you haven't shown the video yet, but what happens next?
I make a passenger side approach to the vehicle. I come into contact with Mr. Wallner and the other occupants of the vehicle. Impairment indicators were observed passing by the vehicle and just began staring at sobriety testing.
So Mr. Wellman was driving the vehicle.
Yes, sir.
And you said something about additional indications of impairment?
Yes.
What did you observe specifically?
When I made it to the window, looked at Mr. Wellman, I could see that his eyes were watering and bloodshot. I could detect the odor of an alcoholic beverage emitting from the vehicle. It was moderate in strength. When I asked Mr. Wellman about if his address on his ID was current, he had a moment where his speech seemed to be impaired. I believe his response. I said, is this the current address on your ID? And he said, he began, I think it sounds something like, I used it 1707 or something like that, which is the beginning of his address. That right there caught my attention. I asked him if he consumed any alcoholic beverages that evening. He said he had wanted to. So those are apparently things that were observed.
So what did you do as a result of having learned that additional information?
Combining his driving with what I witnessed at the window, his own admission, I asked him to step out of the vehicle for the purpose of ensuring he was safe to drive the vehicle.
Is this your body cam?
Yes, sir. This also has a 90-second retroactive recording, so when the moment is activated, it adds anything that happened prior to 90 seconds of the video.
What is that that he gave you?
I believe that's a certification for a spare tire lock, something like that. It wasn't what I asked for, but if I recall correctly, it is not Mr. Wellman providing that. It was his girl, significant other in the seat next to him.
Now, you were on the opposite side of the vehicle from Mr. Wellman at that point.
That's correct.
And you smelled alcohol?
Yes, sir.
Later on, did you check the young lady that was in the passenger seat to see if she had been drinking?
Correct, yes. She did not display any signs of impairment.
So there wouldn't have been an alcohol smell coming from her?
Objection. Calls for an expert opinion, Your Honor.
I don't think so. I'll let him answer that if he can.
Could you repeat that?
Well, you actually gave her a preliminary breath test to make sure she didn't drive the vehicle, right?
Correct.
Did it show that she had been drinking any alcohol?
No.
This is pretty spare tire. Just like we did right back there. We have since I am there. Is it really good? This is good. Man, that's not that big a deal. That's okay. That's all the current state here is, current time. Okay. How much you have to drink tonight? Yeah. Okay. Gotcha. I'm not.
You asked him how much you had to drink tonight. I couldn't hear. What was his response?
1 or 2 drinks.
That's not from the corner. You have a little water in your bloodshot. That's why I asked. Well, I ask you to just step out. I'll make sure you safe to drive. If I see you, you're ready to be up in a few minutes, okay?
that you could hear on audio, I asked him to step out of the vehicle, they were just ensuring that he was safe to drive. And he exited the vehicle.
Were you going to then administer standardized field sobriety tests?
Yes, sir.
Are you certified to give those tests?
I am.
Is that part of your training with the Ohio Highway Patrol?
Yes, sir.
Because I think it was alleged in the defendant's motion that you weren't, just stated as fact that you're not certified, but you are, correct?
I am.
As a matter of fact, indication of your certifications available on the Ohio Department of Health's website, isn't it?
I don't know if it's made available via that website. I don't know if it's going to be certified.
I've marked this as plaintiff's exhibit 1 for identification. I'd ask for you to
This document is my certificate that I received for successfully completing NHTSA's standard field sobriety testing training provided to me at the Evidentiary Academy.
and that's still valid.
Yes, sir.
I ask that exhibit 1 be admitted.
Any objection?
No objection, Your Honor.
Be admitted.
So you conducted a field sobriety test, is that right?
Yes, sir.
What was the first one that you did?
The first actual test conducted was horizontal gaze and stagnance testing, but I have a series of things I do prior to that test.
Okay, I would like for you to start with the stuff you do before the testing and walk us through the entire process.
Sure. One of the first things, or the first thing I do is I'll ensure that my forward flashing lights on my light bar are deactivated and that the scene is free of any potential flashing lights, strobing lights to prevent optokinetic stagnance or anything of that nature.
Did you do that in this case?
Yes, I did. The second thing I'll do is I'll ask a series of preliminary questions to better understand the individual's standard field sobriety testing performance. And it's a general set of questions, and then depending on my answer, I'll ask follow-up questions potentially. The general questions I ask are, do you wear contact lenses and glasses? Mr. Wellman said that he did not. Secondly, I'll ask about medications. Mr. Wellman informed me that he was not taking any at the time. I'll also ask if they consider himself to be in good physical health overall. Mr. Wellman said that he was. And finally, I'll ask if there's any history of head injuries that caused that person present-day issues. Mr. Wellman told me that he had no history of that. Next, I will move into my pre-check of the eyes, meaning I'm looking for pupil size to be equal in the individual. I'm looking for resting stagnance, and I'm also looking to make sure that their eyes track equally. Mr. Wellman's eyes did all three of those without concern. There's no abnormal indicators present or anything of that nature. Then I move into horizontal gaze and stagnance testing.
Okay, and so I would like for you to explain the different parts of the horizontal gaze and nystagmus test, what they indicate, and what you saw in this case.
There's three things that I'll check for in each eye. So if I'm looking in each eye, there's three total. There's 6 clues. Clues being the word that NHTSA uses in the manual to indicate, things that can indicate impairment potentially by certain drug categories. For horizontal gaze and stagnance, you're looking for depressants, or what it can indicate is the impairment by depressants, inhalants, or dissociative anesthetics. Alcohol is a depressant, just for reference. During those 3 things I'm looking for, the 3 being lack of smooth pursuit in each eye. Checking both eyes, Mr. Wellman did exhibit a lack of smooth pursuit in each eye, so I already had 2 clues.
Let's explain to the court what lack of smooth pursuit means.
Okay. So, in general, for a person not impaired by a depressant, inhaler, or dissociative anesthetic, their eyes will track smoothly as they follow a stimulus.
So the stimulus is out in front of their eyes
12 to 15 inches. And what I'm looking for there is, as the individual is following that stimulus, I'll tell them, hey, make sure, I'm asking to follow the very tip of my pen there with your eyes and eyes only. As I'm moving that, their eyes should follow smoothly. If a person, or patient can be, caused by, or lack of smooth pursuit of HN can be caused by impairment from precedent associated anesthetic. If that impairment is present, what that will look like is it's not smooth. As I'm moving my stimulus from side to side, their eyes are trying to keep up with it in a jerking motion. That's what nystagmus is, the voluntary jerking of the eyes, and I'm looking for that. If that nystagmus is not present, they're going to be following it smoothly, just as I'm moving it, rather than that jerking motion.
So there are 3 different variations of that test that you use to come to a conclusion?
3 parts of it, yes.
3 parts, and so tell the court what those 3 parts are.
Lack of smooth pursuit in each eye, so I've already talked a little bit about that. Distinct and sustained nystagmus at maximum deviation. So as I'm holding that stimulus, at the furthest point in which their eyes can remain sustained on it. If they are impaired by those drug categories that I mentioned, what will generally happen is the eyes want to go back to center. So it creates this jerking motion and this nystagmus because somebody who is not impaired by those, what those guys, they remain fixated on it. They don't have that jerking, they're just fixated on it. At a minimum, I have to provide that stimulus for 4 seconds, but no more than 30. If you hold it beyond 30 seconds, there's concerns with fatigue of the eye.
Before you start that test, are you required to give the person you're giving the test to certain instructions?
Yes, so for example, like I had said, I told him to look right at the tip of my pen there, to provide a stimulus, and follow with their eyes on it.
And what other things do you also advise them to do?
So prior to that, I'll have them stand with their feet together, hands down on their side.
Did you give those instructions?
Yes, I would say.
The NHTSA manual states them in particular terms. And did you impart that information correctly, even though you might not have said it word for word what the NHTSA manual says?
Objection, Your Honor. I believe that you have to actually refer to the language of the NHTSA manual.
I'll allow him to give a statement if he believes he complied with it. He can prosecute him.
Yes, I did.
And I'm going to show you what we're marking as Plaintiff's Exhibit 2. And ask you to tell me what this document is.
This is the first page of my periodic report. This is Highway Patrol's Form 70B, and this has a general summary of my observations of the impaired driver.
Is there a place on there to report your findings on the horizontal gaze nystagmus?
Yes, there is.
And what did you report in this case?
So out of 6 clues I'm looking for, Mr. Wellman exhibited all 6 to show 4, or exhibit 4 more clues. The NHTSA manual through the San Diego study, 1998, says that with that, there's an 88% likelihood that this person is impaired by the categories I mentioned earlier.
And I'm going to ask you if you know what that page is.
This is a page from the NHTSA standard code sobriety testing. This goes over nystagmus indications. Again, it references the 88% accuracy in technically impaired persons. 88% meaning that they've exhibited 4, at least 4 of the 6 clues. If you exhibit 4 or more, there's 88% likelihood that they are at 8.080% alcohol, BRAC, breath alcohol content, or higher.
So you got how many clues? 6?
6 of 6, yes, sir.
Your Honor, we're going to ask for Plaintiff's Exhibit 2.
Any objection?
I just want to make sure, the impaired driver report.
Yes.
The first page of it.
Right.
No objection, Your Honor.
You admit it. And this one's marked.
That's fine.
So there's video of the HD pass, right?
Yes, sir.
When I ask you to do so, this is got a VIN number on it. It's not that big a deal. That's okay. I saw the current state here, is current stuff. How much you have to drink tonight? Yeah. Okay, gotcha. I've got something, the corner guys, a little water, bloodshot, that's why I asked. Well, I ask you to just step out. I'll make sure you take the drive. If I see you, you can go to the other one in a few minutes, okay? Give this one a second. How you doing, NHTSA? Like I said, I'll send a couple of checks if you don't mind, and if I see you, you do one way. You say I have on the front license plate. You said you're getting her brother up? Gotcha. How long did you have your drinks? Good, they didn't have how many? Okay, gotcha. Well, I ask you to do, stick your hand, you can put them on that side of the hood there. Yeah, they want to go around. That's okay, you do it. That's right. So what I do is stick your feet together there for me, please. Hands down your side, put your ear contacts and glasses. Okay, we don't need medications of any kind. Excuse me, sorry, they don't hurt your face there. So not just, would you consider yourself a good little out? Yeah, you use your hands, you're supposed to cut the days. What I ask you to do, so where do you go, man? Tyler, that's your name. What I ask you to swallow any tip of my pen there, with your eyes and eyes on, what you put your hand, okay? Stay right on the table. Please say the name, keep going, good. Very good, perfect. You can walk right over here for me. I know you got boots on, so I'm going to explain to you what I'm asking you to do.
I'm going to ask you what this is.
That appears to be the NHTSA manual sniffers by testing in 2018.
And you been trained in all the principles contained in this.
Yes, also received the 2023 update.
I've copied some pages out of this manual.
Yes, sir.
And I'm going to show you those and ask you to make sure that they match the ones in the manual.
Page 30 through 37.
37.
Yes, sir.
So, what are those pages about?
HGN testing, goes on against status testing.
And is it your testimony that you followed all of the directions from NHTSA in a substantial way when you did the horizontal gaze and nystagmus testing?
Yes, sir.
Mr. Wellman?
Yes, sir.
Let me get that back.
Yes, sir.
Here's the administrative procedures. I'd like for you to go through each one of those and say, name it, and then say whether you did it or not.
First is check for eyeglasses. I'll still ask if they wear them, even if they're not wearing any. Some people maybe left at home or don't wear them, they should.
Did you do that?
I did. Give verbal instructions, position stimulus 12 to 15 inches, slightly above eye level. Check for equal pupil size and resting nystagmus, and check for equal track.
Did you do all those things?
Yes, sir.
Okay, let's go on to the next page here. Start with number 6.
Okay. Talks about, this is still administrative procedures. If there's a lack of school pursuit, distinct and sustained nystagmus and maximum deviation, set of nystagmus prior to 45 degrees. The 3 sections that I covered and discussed. And then 9 total number of clues. I had 6 of 6. And then 10, check for vertical nystagmus. I did not check for that.
Did not check for vertical?
That's correct.
Why would you not check for vertical gaze nystagmus?
Vertical gaze nystagmus gives us, if it's present, suggests that it's a high dose for the individual. It does not help engage whether the person is believed to be at 0.080 or greater in terms of breath alcohol content. I generally, as a rule, do not do that. It's my personal choice. No other reason.
On page 33, it states what the instructions should be. And I'd like for you to state what those things are and whether you stated them to Mr. Wellman.
Okay. So some of this here is, okay. So you're talking about step 2, verbal instructions?
Yes.
Okay. Give the subject the appropriate verbal instructions. Put your feet together and hands at your side. Keep head still. Look at the stimulus. Follow movement of the stimulus with the eyes only. Keep looking at the stimulus until the total test is over.
Did you do all those things?
In substantial compliance, yes.
And everything else with respect to equal tracking and smooth pursuit and previously tested.
Sorry, yes.
And this appears to be a direct copy from the NHTSA manual.
It does.
Nothing different about it. It doesn't comply with what you know already to be in the manual.
Correct.
I'm going to ask these for you to do that.
Any objection?
I'm no objection, Your Honor. I believe he has to admit the entire manual. He can't just admit selective portions of the manual.
Okay, I'll take your objection under advisement.
If Mr. Whatever Haslam wants to buy another manual from me.
Your Honor, it's not my burden to purchase things for the state. It's the state's burden to introduce evidence. If he wants as an exhibit, he would have to put it in as an exhibit.
All right, your objection's noted.
So in paragraph 3 of the motion that we're here on today, It is alleged that the officer did not have the defendant remove eyeglasses. Was he wearing eyeglasses?
No, sir.
Or as if he was wearing contacts? Did you do those things?
I did ask, yes.
So that's false, right? He says you didn't do those things.
Correct.
The defendant was facing rotating lights, strobe lights, and traffic passing in close proximity. Were any of those things true?
No, sir.
In dusty and windy conditions. Was it dusty and windy?
No, sir.
So none of those things are true.
Correct.
So what did you do after the horizontal gaze was done?
I moved into preparing for the walk and turn test, which is the next test that will generally provide for sample sobriety testing.
So what's the walk and turn test about?
It's divided attention skills. There's an instruction phase, so I'll have them assume the starting position. I'll explain it to them. What I'm asking them to do, once they assume that position, I will explain it and demonstrate the instructions of the walk and turn test to them. We're already looking for 2 clues during the instruction phase out of a total of 8 for this test. An indicator of 2 clues or more for this test, per the NHTSA manual, suggests that there is 79% likelihood that this person is at a BRAC of 0.00 or greater.
So what's the starting position?
So I'll first, if there's not a suitable line available, I will ask them to imagine a line going from them to some part of my car. A lot of times it's my front license plate. Sometimes it's the headlight. If conditions, I'm trying to put them in the best position possible, meaning that it's level, it's solid, that it's free of putting the burden on them just from the simple standpoint of gravity. I'm not going to have somebody stand on the incline rail or in a rocky situation because that's going to interfere with me to successfully determine whether or not this person is impaired. So in this starting position, while I'm demonstrating and explaining the instructions, I'm looking for 2 clues possible. That being whether or not they started too soon, and if they move their feet for balance from the starting position. If they exhibit either one of those 2 things, those are considered clues per the NHTSA manual. From there,
Let me ask you this.
yeah.
Do you make sure that you told them they got one their position before you start grading them on that?
Yes, I'll say inches, they like that until we read it again. And I'll make sure that they understand before I continue.
So you have preliminary instructions that you give to get in that position?
Yes.
And then you demonstrate the test after that?
Yes, I apologize. Circle back to your original question. What you asked what the starting position was?
Yes.
So I kind of started it down that line. I asked them to imagine a line in this case, because I'm not going to have somebody use the fault line. That's part of the lane of travel. I'm not going to have somebody stand basically the road while we have cars passing. So in this case, I asked them to imagine a straight line going from him to some portion of my vehicle. I don't remember if it's the license plate or the headlight or something. Sometimes I'll refer to my tire depending on how my car is positioned. From there, once he says and affirms that he can imagine that line, I'll ask him to take his left foot, put it on that line that he's imagining. And once he's done that, I'll ask him to take his right foot, put it in front of his left foot, touching heel to toe. Keep your arms down your side. Don't move till I tell you to begin. You understand? That's the starting position instruction.
Now, before we go any further, is this also a standardized field sobriety test that you've run through your NHTSA training?
Yes, sir.
So up to that point that you've explained so far, did you do those things with Mr. Wellman?
Yes.
And so, then you demonstrate the test, is that correct? The next thing you do, and explain to the court what you did there.
Yes, sir.
Go ahead.
Oh, I'm sorry. Okay, so moving on from the starting position. So once they're in that starting position, I will give them a kind of a rundown of the test and show them the detail I'm looking for. In this case in particular, I noticed Mr. Wellman was wearing boots. I personally own a pair of pull-on boots myself. I wouldn't, they're still typical ones I have. Me personally, I don't really like walking around in, but some people might be more than comfortable asking Mr. Lowen. If he wanted to remove his boots for the test, he offered to put on some tennis shoes just for his own safety as well as my own. I wasn't going to do an outfit change on the roadside, so I told him, it's up to you whether or not you want to remove your boots just for your own comfort level for performing this. He opted to leave them on. That was his personal choice. He felt comfortable, I guess. From there, I explained to him that I'm going to ask you to take 9 heel-toe steps along the line you imagine, turn yourself around and take another 9 back. You understand so far? I wait for their approval and their affirmation that they do. I'll then say, okay, I'm going to demonstrate it for you. I get in the starting position myself. I'll demonstrate the test up to three steps. I'll tell them that I'm asking them to take 9, show them how to do the turn, and then again walk back in line, do 3 more steps of my own as I demonstrate. From there, I'll remind them that it's that they need to keep their hands down on their side. They need to look down at their toe or their feet. They need to count their steps out loud, and they should not stop until they've completed the instructions.
Did you do and say all of those things in this case?
Yes, sir.
No, I would have the exhibit is this portion. That one, I probably need to I'm going to refer you back to page 2, which you identified previously. Does that also contain information about your observations of Mr. Roman's performance in the walk and turn test?
Yes, sir.
And specifically, what did you observe there?
3 out of 8 crews. Again, as I mentioned earlier, exhibiting 2 of the 8 or more is for the NHTSA manual an indication that this person is 79%, has a 79% likelihood of being impaired.
And what specifically were the things that you observed?
He moved his foot for balance while in the starting position. He took 10 steps down the line rather than 9 as I had instructed, and he made an improper check.
And I'm going to show you again. And look through this and see if it matches the pages in the and also tell me what it is you're looking for, or looking at here that I've had marked as exhibit 4. Is that 4?
This is session 8 coverage in the NHTSA manual of the walk and turn test, pages 61 through 69. It appears. It does appear to be the same. Just copies.
So you're familiar with those pages?
Yes, sir.
You've been instructed from that same set of pages?
Yes, sir.
And in this case, did you follow in a substantial way the requirements and the directions in the NHTSA manual?
Yes, sir.
When I see exhibit 3.
Same objection?
Yes, Your Honor.
Subject to that objection.
Let's see. I'm having you look at the video here.
Yes, sir.
I was saying, if you want to do boots on, that's fine. If you want to do boots on, that's fine. I was planning you to make a decision, okay? So what I'm asking you to do at this point, the only thing I want you to do right now is imagine a straight line going from you to my front license plate. You able to imagine that straight line? All right, you take your left foot, put it on the imagine. You take your right foot, put it on your left foot, touching the other toe. Actually touching the other toe, there's kind of offset, see what I'm saying? Perfect. Hands down on your side. Don't move that toe. Yeah, don't move that from your begin, okay? Okay. Did you hear what I said? Right now. I just want you to stay like that till before you begin, okay? That's right. No, I mean like right foot from left. I was just telling you don't begin until I say it, okay? One of actually do time is take a series of 9 double steps along that line, you imagine. Turn yourself around and take another 9 back. There's a little more to it, but you want to do that with the boots on or off? I'll just show you the boots off. I don't think it'll, this here is just like, you don't have to. I'm just giving you the option. You feel comfortable doing it. It's up to you. I just want to give you the option so you're comfortable. So right foot from the left hand heel toe. I want to demonstrate it for you. Just stand as you're over there. Again, don't begin until I told you to. So you're in the starting position that your hands going to look like this. 1, 2, 3. 3 heel-to-toe steps. You'll take 9 on that 9 heel-to-toe step. Keep your front foot touching the ground. Use your other foot to turn yourself around in series of small steps like I'll do. Once you turn yourself around, take another 9 back. 1, 2, 3. Again, I took 3 heel-to-toe steps. You'll take 9. Any questions about what you saw? As you do this, just make sure you keep your hands down to your side. Do it down to your feet. You count your steps out loud, and you don't stop till you complete the instructions. Does that make sense? Any questions for me? The other thing you may be is on it. Next thing I ask you is going to be the last thing I ask you to just stick the feet together forward, please. Hands down at your side. Don't begin until I told you to. You understand? Yes. One last.
Paragraph 4 of the motion says that the test was not performed by defendant on a designated line. You very clearly pointed a line, an imaginary line out for the defendant, didn't you?
I gave him a point to focus on, yes, so you could imagine.
Didn't take place on a dry surface. Was that a dry surface?
Yes, sir.
Was that a hard surface?
Yes, sir.
Was it a level surface?
Yes, sir.
Was it a non-slippery surface?
Yes, sir.
And did he have sufficient room for the defendant to complete 9 heel-to-toe steps?
Yes, sir.
So none of those allegations are true, are they?
Correct.
Now, it also says that you didn't limit your movement and it distracted the defendant. Is that true?
No, sir.
Were you standing still?
Yes, sir.
And prior to the test, did you ask him about any physical issues that might impair his ability to do the test?
I asked him, yeah, if he considered himself to be good physically.
Okay, that's all on the video.
Yes, sir.
What did you do after that test?
The one leg stand test, which is in terms of validated tests, what's included in that manual, that's the last of them. There's 4 clues that we're looking for. Just like the walk and turn test, 2 clues that are included are an indicator of impairment up to a 83% success rate.
So you did administer the one-leg stand test.
Yes, I did.
Now, I'd like for you to explain to the court what the test is for, what you're looking for, how you conduct the test, and what instructions you give.
Again, in terms of the question of what it's for, it's a test that's been validated to help me make a determination as to whether or not a person is impaired by the drug categories that I mentioned before. In this case, you already heard me explain the starting position instructions. Mr. Warren said he understood. The starting position is just having them stand with their feet together, with their hands down on their side, and iterate. You do not want them to move to the forward. Once the test begins, and I've explained and demonstrated for them, there's 4 clues that I'm looking for. But the instructions given are, this is the way I tell them. You take a foot of your choice, left or right wing, doesn't matter. You take that foot of your choice, hold it approximately 6 inches above the ground, and parallel with the ground, like mine is, because I'm demonstrating at that time. I want to draw attention to my foot so they understand what I'm asking of them. Hold it 6 inches above the ground, parallel with the ground, like mine is. Keep both legs nice and straight, but bend your knee. Keep your arms on your side, go down to your foot. Count in series 1000s like so. 1001, 1002, 1003, 1004, and so on until I told you to stop. That's my instructions. Give or take some wording, for the most part, down to order. My instructions.
Did you do that in this case?
I did, yes.
Is it in substantial compliance with the guidelines as prescribed by NHTSA.
Yes, sir.
So this is a standardized field sobriety test.
Yes, sir.
I'll show you again the manual and some pages that I asked for you. And I have marked this plaintiff's exhibit 6, 5.
Section 8, for the NHTSA manual standard sobriety testing, referring to one night stand, pages 72 through 78. Those appear to be exact copies of it.
Did you follow those in substantial compliance?
Yes, sir.
Doing this one, take a vote of your choice. Left or right one, it's totally up to you. Take that vote of your choice, hold approximately 6 inches above the ground, and parallel with the ground like mine is. Both legs nice and straight, no bend in your knee. Keep your hands down to your side, but down to your toe, not just yet. Not just yet. You put your foot down. I'll tell you when. With your hands on your side, down to your toe, count series of 1,000s like so. 1,001, 1,002, 1,003, 1,004. And so on until I told you to stop. Does that make sense? Any questions for me? Okay, if you understand the instructions, Tyler, you may begin. Get down to your toes there. You pick up as you left off.
What specifically did you observe during that test that would indicate that he had clues?
You specifically asked me to tell you what validated clues I observed?
Yes.
2 or 4, he puts it out twice, which is one of the 4 clues. The second one was that he sways, he puts it out. Additionally, though, in terms of clues that weren't validated as things that they're not considered clues, but still observations I made. I have them go for 30 seconds, Mr. And I tell them, I don't tell them how long, but I tell them to perform the test until I tell them to stop. It's 30 seconds, I have a stopwatch. You can see me prepping on a watch on the screen, or at least reaching down there feeling something. That's what I'm doing if it wasn't clear. Mr. Willen stopped after 17 seconds. I had never said stop. He stopped of his own accord. I asked him if he was done. He said yes. So I said okay.
So you wouldn't have said keep going until we get to 30?
Correct.
I'm going to ask the plaintiff's exhibit 5 be admitted.
He admitted, subject to the same objection. Okay, I'm going to take a break now and do Lawson is at the jail. That's the last person to do that. And we'll, Mr. Morford, are you ready? You've talked to her?
Yes, Judge.
Okay. And you've got the court's file, I believe.
I do. I have a couple of new contacts for you as well, Judge.
All right. Ms. Lawson, can you hear me? She's on my screen, and she can see the courtroom. Don't go too far, because it's going to take very long.
Yes, Your Honor.
For recall, State of Ohio Police Department, also case number CRP 22709.
All right, so we're looking to get her into the counseling center, perhaps?
Yes, Judge. I've been through about 4 or 5 different people and finally have gotten hold of people that are in charge of making the assessments and stuff. They're going to try to, they're making a determination now as to whether or not they need a new assessment. She's had one earlier this year, but they are willing to take her back. They're making a determination as to what kind of, if any, assessment needs to be made.
Mr. Hill, do you have any input on that?
If they're willing to take her back, then we're happy to see that happen.
All right, I'm going to do an order that she can be released to the counseling center for inpatient treatment. I'll set bond at $2,000 OR. And then we'll come back on June 23rd for the next hearing, which will be a pretrial, and get a report from the counseling centers to her progress. That's 2 weeks. Okay, so we'll do that order, and then is there, I think that's everything on her?
Yes, sir.
Okay.
Yes, Judge.
All right, that finishes up at the jail then. All right, can we let's get some of these others done. Dylan Hyden. I'm doing it. Dr. Dylan Hyden. Dylan Hyden. I've got his report, and you met with him?
Yes, we're willing to take him today. There's not.
Inpatient?
Yes.
And you're willing to go? Okay, and you're going to transport him?
I have somebody waiting now.
Okay. Set it for the same day, June 23rd. And this should be on the sentencing docket, I believe. No. Preliminary hearing. Preliminary hearing and pretrial. Well, it's actually sentencing on the ODI. Yeah, he's already played on that. He has the felony supplement.
I'd ask Mr. Morford to do a time waiver film for me, please.
Sure.
All right, June 23rd is his next hearing. We'll get a report from Bethesda Dentist to his progress.
Thank you, Your Honor.
Thank you, Your Honor.
Caleb Langdon. This is also Mr. Morford's case. And also being assessed.
What's he doing?
By Bethesda.
Going in. He's going in. We've assessed him, and he has met all the criteria for inpatient, and we're willing to take him today.
Mr. Morford.
I'm on board.
Is he?
He seemed to
Langdon,
be.
you on board?
Are you?
Tested for something that could kill you.
That's fine, yes.
Fentanyl. You got fentanyl in you right now, according to your urine screen.
Okay, so what,
So we want to get off fentanyl. We want to get you clean. It's going to be this is your chance to get this done for free.
okay. Yes, Your Honor, I am.
And what's you're a young guy. Do you have any kids? What's going on with you?
No, recently, me and my girlfriend, we have our own house. We recently, we never been behind on bills or anything like that, but our landlord gave us 30 days to find a different place. And it's just been, it's just kind of all hit me at once because,
Well, you've got a felony, so here's, I'm trying to do this fast because we got a bunch of stuff stacked up. But let me just, because it's really important that you understand. Felonies now mean you can go to prison. In the really old days, a felony meant all felonies were capital punishment, possibly. Didn't mean you had to get it, but you could. Now it just means you can go to prison if you get a felony conviction. And this is not the felony court, so you're here just for the preliminary stuff. And then in the normal course of things, the felony, I send it on down, you have to get indicted by the grand jury. It's so serious that you can't just take the prosecutor's word for it. You got to have a group of people from the community come in and say, yeah, this guy really, we think did this, so we're going to indict him. There's got a lot of stuff in the news about indictments right now. So what the state's saying is they're not even going to pursue any of that if you will go to treatment. If you go to treatment, they're not going to indict you. They're not going to take you to the felony court. You're not going to have any risk of going to prison. But what you got to do is get clean. Take this opportunity, go to treatment, get clean. Now, I know it's not convenient. You got stuff going on with your girlfriend. You got an apartment. But this is more important. You've got fentanyl in your system. Last year, the highest overdose death rate in the United States ever. And the reason? Fentanyl. You get anything off the street, it could have fentanyl in it. I'm sure you probably didn't know. Did you know you were doing fentanyl?
No, I didn't.
Because people tell me all the time, I didn't know. I just smoked some weed.
Yeah,
you get some weed off the street, it could have fentanyl in it.
He also said I had MDMA in my system, and I was like, I don't even know what that is until he explained it to
You
me.
got benzos, fentanyl, and some marijuana. So, serious business. And serious legal business and serious personally for you to get clean.
Yes, sir.
So, yeah, your girlfriend might be upset, but she'd probably be more upset if you overdose, don't you think?
Yeah.
Okay, so let's take care of that. And take this seriously. If you don't take it seriously, then I'm going to send you on. You still have the felony pending. You're going to go to the felony court in Ironton, and then you've got about a 50-50 chance of going to prison, depending on how things work out. Do you want to take a 50-50 chance?
No.
You want the sure thing. You want to take it off the table. Taking it off the table means you going to treatment and doing well, not just going there and causing trouble and not participating. You got to go there, and they will tell me if you're doing what you're supposed to.
Yes, sir.
You understand?
Yes, sir.
And if your girlfriend's got a problem, let's get her in treatment too.
Oh, no, she don't have no problems.
I don't know whether she does or not.
Yeah.
But there's things available to help her if she's got an issue. And it'll make it a lot better for you. If she's dirty, it's going to make it hard for you when you come out of treatment. Okay? So I want to see, it'll set you, all these people will see on the 23rd, and I'll get a report. So they're going to give me a report. If you're doing well, you'll stay here, and eventually you can get your case dismissed. You can't get anything better than that. Get a felony dismissed.
Yes, sir.
Because you want to get a job, right?
Yes, I do.
If you have a felony on your record, that's probably 75% of the jobs or more are out the window. They're not going to hire you with a felony conviction.
Right.
So take this off the table by doing what you need to do in treatment. I'll see you on the 23rd with a good report, right?
Yes, sir.
Okay, that's at 10 o'clock for preliminary hearings and pretrial.
Thank you.
Bethesda. Inpatient.
Thank you, Your Honor.
Okay, well, we'll just have
Hey, Butch,
to, let's do some of
hey,
the,
Butch,
let's do some of the sentencing.
can you do a continuance on Dylan Hyden? And here's another one, Butch.
State of Ohio versus Nathan
I
Doss.
did that one.
Mr. Cremines.
Mr. Cummings.
Case number CRB 23-154, TRC 23-245,
This is set for sentencing. We're going to look at treatment, right?
Madam Pro, Your Honor.
Yes. I think I've already got this. Okay. All right. Okay, this is, Mr. Doss has a multiple prior alcohol-related driving offenses, and he's doing treatment now to try to convince the court that this will be the last one he ever has in his life. So we're starting that process, so we're going to come back down the road and continue to monitor his treatment. Correct?
Correct, Your Honor.
So maybe 6 weeks out for another
That'd be good, Your Honor.
hearing. So far so good. Keep it up. Around July 21st, Mr. Greens, what's good for you?
That'd be fine, Your
July
Honor.
21st? He's now living in Columbus?
He is, Your Honor,
He can appear by teleconference, as long as his reports are good.
Okay.
July 21st for St.
Would it be possible to do that? That's what he just said. I'm sorry, I apologize. Thank you, Your Honor.
You're welcome.
State of Ohio versus Brenda Griner, case number TRC 222709A and B.
This is Mr. Premier, is set for sentencing.
May I approach, Your Honor?
Yes, she's been at Mended Reed.
That's correct, Your Honor.
And we have somebody here from Mended Reed. Can you give me the Dating Myself Reader's Digest version? No one else, I was like, what is that?
What are you asking for, I'm sorry?
A condensed version of the report.
Overall,
Mr. Neal gets it, but nobody else wants it. And you, cultural references went over everybody else's head.
You're fine. No, Your Honor, it appears that the same thing that I have is what Mr. Cremines just turned into you. Overall, she is compliant. She has been since she first came to us in April. She's had negative drug screens as well as, overall compliance with our screening program and meeting with
Okay. So let's see how far we're into this. Oh. It's been since December. What's her, what kind of time frame are we looking at?
So she was originally assessed on April 5th, I believe.
Okay,
was
so
the date
she
of her
hasn't been
assessment.
that long.
Yeah, we're getting close to 2 months. Hasn't been too long.
Okay, we need to go further. I was thinking maybe it had been longer, but it hasn't been. So same time frame, same.
That'd be fine, same date, Your Honor.
And that was the 21st, right?
Yes, Your Honor.
July 21st for another sentencing.
State of Ohio.
Good job, keep it up.
Thank you, Your Honor.
State of Ohio versus Clyde King, case number TRD 202187 ABC, D&E, and CRV 2825.
Your Honor, if I may, I have a note that we're looking for a report from the Huntington Police Department on Mr. King. He said he was in on the hospital or whatever community service.
He indicates that no report was filed.
They never filed it. I was there, I called them, I went over there.
Okay, well, you still have 36 hours of community service. I need you to either go to the
Still
jail
don't have
today
one
or
day
be out
left.
tomorrow morning for community service. Which is it?
I do community service.
Yeah, it's an easy choice, I think. So
Just gonna have
you
one
need
day
to be
left.
here in the morning at 7:30.
All right.
Thank you, Your Honor. Oh, we're gonna set another date or not?
We're gonna set another day, and then if he doesn't show up, it's gonna have to be jail.
Okay.
But you don't wanna go to jail.
No, sir.
July 10th will be his next sentencing hearing. And do more than just, but you have to be here tomorrow, but I want to see more.
All right.
Let's get your
I still don't have one day.
community service wiped out. But,
State of Ohio versus Tracy J. McDonald, case number TRC 222574, ABC, D&E.
he still has a case pending on the
That's
SCIP.
what I was told, Judge. I don't have his file, but I was told the B case was still unresolved.
It was going to be dismissed once he completed treatment. That was the deal.
Your Honor, I do have a report.
Okay. Okay, it's a good report. I think he went over with the clerk with the clerk this morning as to what's actually owed. I mistakenly told him last time that some had been forgiven. $600 had been forgiven.
Yes.
But it was off the 1,000, not 685.
It's my understanding.
685 was what he owed.
I spoke with this place earlier, so I would concur.
Okay.
They got some money on the dedication of the CBD.
Yeah, that was just that one.
Yeah.
That was the ODI.
Correct.
Okay. And there's others too.
There's like A through D in several cases.
So he's still in treatment?
Yeah.
Once that's completed successfully, then the leaving the scene case will be dismissed. That was the deal. Correct?
That's my understanding, Judge. That's my recollection.
Okay.
We have a sentencing for him already set up for July 10th.
We'll put this on that date also. July 10th.
That's fine.
Next year. Keep up what you're doing. You got a good report on your treatment. Keep it up.
What's the date?
July 10th.
State of Ohio versus Jeremy A. McMillan, case number TRC 22769, A, B, and C, TRC 2024-10, A, B, and C.
Jeremy actually here?
He was here, well, a couple hours ago I saw him.
TRC 14-20.
All right.
You want to call Judge first and explain he didn't show up. Yeah.
Jeremy almost got me barred in from my law license in West
But he was here earlier, I just made sure we stayed.
You were on the road to Damascus, you saw the light, and now you've repented and gone, you're doing what you need to do, correct?
Yes,
sir. Absolutely, because I may go to jail with you. Judge Ferguson will put us both in jail if you mess up.
We ain't gonna go that route.
Okay, so he's doing well?
Yes.
Okay. Good job. Keep it up. You look a lot better than you did when you were over in Western Regional.
Oh, yeah.
You were there for about 3 weeks or something like that? Or?
Yeah, almost 30. Almost a month. Yeah.
Yeah. Jail's a place to avoid.
Yeah.
Keep that in mind the next time some girl
Shower
calls you
3
and says
days.
she wants you to leave treatment. Say, you're a really nice girl, but I don't like jail. So I'm going to stay out of jail.
Sir.
Let's do a month. So July 10th, July 14th?
I think I'm here the 10th from that last one anyway, yes, for Tracy McDonald. I can do the 10th.
July 10th.
Yes.
Thank you, Your Honor.
Okay, Jeremy, good job.
Thank you.
Keep it up.
Yes, sir.
State of Ohio versus Jesse J. Bentley, case number TRD 21-2464 and TRC 183773. Jesse Bentley.
Jesse Bentley. Jesse Bentley was at Hometown Recovery. Anybody here from Hometown?
They look, Your Honor.
Okay. Well, he's not, he or she, I don't remember if it's a he or she. It's not here.
It's just, yeah.
So we'll get a warrant.
State of Ohio versus Beverly M. Hines, case number TRC 23-182 and TRC 22-2783, A and B. Beverly Hines.
This is Mr. Morford's case too, sentencing.
Judge, she called my office early this morning and said her child was sick and would not be able to make it to court today.
I'll continue it to Monday. You're here Monday?
Yes, sir. Yes, sir.
Well, at defendant's request for sentencing.
State of Ohio versus Ronald R. Spears, case number CRB 2140. Ronald Spears.
Ronald Spears, he has a bond up with Erie, salaries. So. Put this one on my desk, I want to look at it, see if he's finished. He might be finished, but I'll review it after the court.
Judge, that was Mr. Soured's feeling, because I was, apparently last night, I called him and told him it was on the docket for today. And he checked and said it wasn't in the jail. Said he checked the court website, looks like he made 2 payments at the beginning of June. His case may possibly be finished.
So I'll review it.
He gets a warrant every month and I have to call him and it goes in the next court day.
State of Ohio versus Amber Mills, case number CRB 2312, TRC 171164.
All right, this is for sentencing.
May I first?
Yes.
Ms. Mills was referred to us through Ironton Municipal Court on domestic, and she's inpatient. She came in, she was done really well, and then we had a little incident the other night, and I think she's kind of redeemed herself from that.
Okay.
She realized that we want to, hopefully she realizes that we really want the best for her.
So that's all smoothed out now?
Yeah.
Okay.
I was being dramatic.
Okay, so we'll keep plugging away then, all right?
Yes. Do you want me to, I have court with Ironton the 17th of July. If you want to post it after that, I'll know more about.
Are you, is that common please, or?
Yeah, just Judge Waldo.
It's municipal.
No, it's Iron Municipal, okay. July 17th?
Yeah.
Okay, we'll make it the 21st.
Okay. Thank you, Your Honor.
I'm going to be sitting for him sometime, but I don't think it's that date. July 21st.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kelly Ann Spears, case number TRD 213262 A and D.
Sentencing, and she's at Safe Harbor.
Yes, sir. For a couple more days. She has found her house.
Okay, very good. And you got a driver's license?
Yes.
In Kentucky, right? Yeah, let's get a copy. Where my mother's family's all from. All filled. Okay, I'm gonna, since you got the license and you've done well on treatment, I'm gonna dismiss this. That'll be your reward. Cases are dismissed.
Thank you so much.
If you want that, well, you will want that back.
Yes.
He's gonna copy it, put it in the file. You'll just hang around till Mr. Cooper brings it back to you.
Thank you.
Good job. Okay, we're back to Tyler Wellman. Trooper Beam is back on the stand. He's still under oath and still in direct examination.
Where are those 3 pages that we need to look at? I'll get these later. We had just finished talking about the one-leg stand, is that right?
That sounds correct.
Okay.
That's my recollection too.
In paragraph 5 of the motion, you are alleged to have not independently timed the test. Did you independently time the test?
Meaning what?
Well, I mean, that's what it says. I would assume it means you're supposed to count along with.
Okay. So what I do is I use my timer on my watch. It's always been working properly, never had any issues with it, so that's what I always use, if that answers your question.
So you did do that?
Yes, sir.
Because this says you did.
Okay. One second.
Did you discontinue it after 30 seconds?
No, never had that opportunity. Like I mentioned earlier, Mr. Walton terminated it. I was in a court prior to that.
Because it says here you let it go on after 30 seconds.
No, that's what I did not.
Was it performed on a reasonably dry, hard, level, and non-slippery surface?
It was.
So that's not true.
Correct.
Before you did the test, did you inquire as to any physiological problems that would keep him from being able to successfully do the test?
I asked him if he had any physical conditions, or if he, excuse me, I did not ask him. I asked him if he considers himself being good as well. Well, he said he did.
So that's not true.
Correct.
Now, by the time you had finished the 3 standardized field sobriety tests, you had been in the presence of Mr. Wellman for a few minutes. Did you observe any other clues during that time that helped you decide whether you felt that he was impaired for purposes of driving or not?
I made mention of, he terminated the one-leg stand prior to me telling him to stop. There's validated clues that we've talked about. I told you which ones I observed there. It's documented in our report as well. There's other things we looked before that are not validated. So, for example, on a walk and turn test, Mr. Wellman was instructed to count his steps aloud. He did not. If I recall correctly, I also believe he did not count a series of 1,000 to the instructed to do so for the one-leg stand test. He remained silent.
When you first encountered him, you indicated that you had smelled a moderate odor of alcohol.
Yes.
And he was on the other side of that cab. When you were in closer contact with him, what did you observe?
That there's still an odor of alcoholic beverage emitting from his breath. So I say still, I should clarify. When I first observed the odor, I observed it emitting from the vehicle. However, when Mr. Wellman was separated from that vehicle and its occupants, I was detecting the odor of an alcoholic breath, an alcoholic beverage. It was moderate strength emitting from his breath while he spoke.
So after completing the one-leg stand test, what did you do next?
I offered him a preliminary breath test. That's the final part of the pre-arrest screening. There's 3 phases of standard field sobriety testing, each of which had 2 tasks. That is the second of 2 tasks for phase 3. I asked him to provide a preliminary breath test.
Just in case it wasn't covered, and I want to make sure it was, you mentioned divided attention.
Yes, sir.
What does that concept entail, and how is it used in these tests?
You're giving them instructions to do, one thing while you ask them maybe a question or something like that. Common things that we'll do when you go to the vehicle before you ask them to exit that vehicle. For example, can you show me your registration while we're looking for the registration? I ask questions like, where are you coming from tonight? If there's indicators that divided attention skills are impaired, a common thing that we'll see is they stop looking for the registration and they start focusing on my question, where you're coming from tonight. They can't do 2 things at once. Most people can complete a couple of tasks within reason. I'm not asking them to provide registration and something else that's physical, but I'm asking them questions while he's doing that thing.
Any of those things built into the field sobriety
Yes,
test?
absolutely.
What are those?
Like I made mention of during the test, like when he's standing in the starting position for the walk and turn test or the long leg stand test, I'm giving him instruction. I'm asking him if he understands what I'm saying. That's built into that process. Can he, remain in that same position? Can he maintain his balance and focus on balancing while in that starting position, for example, the walk and turn test?
And Your Honor, I apologize. When Mr. Hill took exhibits back from me, I accidentally handed him my copy. Yes.
Okay.
Thank you.
Trooper, you had talked about percentages according to NHTSA, and I want to go back to the pages of the NHTSA manual that discuss that, and tell me what that says there at the trial.
This refers to the one leg stand test. In section 7, this discusses, the accuracy in identifying persons who have a BRAC of .00 or greater. If you observe 2 or 4 clues from the one leg stand test, there's an 83% likelihood they are at a BRAC of .080 or greater.
That's what that page there says?
That's correct.
And that's an accurate copy from the manual?
Yes.
And in this case, would your test results have indicated that percentage of likelihood of impairment?
Yes, I did observe 2 or 4 clues.
And I've had that marked as plaintiff's exhibit 7 on the last that we did.
Same objection.
Same objection, subject to that.
I'll show you what I've had marked as plaintiff's exhibit 8, ask you what that is.
This is session 7's reference to the walk-and test. It discusses the accuracy of the test and detecting persons who have a BRAC .080 or greater. Just maybe for clarification, the manual says BAC, but if you look in the vocabulary that's provided in that manual, it talks about the difference between BAC and BRAC. BAC refers to blood alcohol content, BRAC refers to blood alcohol content. In this situation, we're talking about blood alcohol. I'm just explaining to you why I use BRAC rather than BAC.
But that rule still applies.
Yes, sir.
And does that appear to be an accurate representation of the page out of manual?
It does.
You're familiar with that already?
Yes, sir.
And I'm going to show you plaintiff's exhibit 9 for identification. What is that?
Section 7's coverage of the nystagmus indications. So, horizontal gaze nystagmus, again referring to BAC and the likelihood and the accuracy of it. If they exhibit 4 clues or more, it's 88% accurate detecting persons that are the BRAC of .080 or greater.
I'm going to ask that exhibits 8 and 9 be admitted.
Same objection, Your Honor.
Be admitted subject to the defendant's objection.
So as a result of everything that you saw and did up to that point, what was the next step?
After the preliminary breath test,
Yes.
I made the decision to arrest based on his performance and my observations prior to the stop and during personal contact. From there, placed him on arrest and informed that he was being arrested for operating a vehicle while impaired. I organized and searched and secured my patrol car. His vehicle was released to the front seat passenger with his permission, as well as the other occupants of the vehicle.
Did you offer him a chemical test?
I did, okay.
Did you advise him properly about the legal aspects of that as far as his maybe potential refusal to take such a test?
Yes, sir.
What's the name of that document that you use?
It's the Bureau of Motor Vehicles 2255 form. That goes over what happens if you do not provide a breath test, what it means if you have a prior conviction with an ODI, and how penalties can be enhanced, and how your vehicle can be subject to mobilization or forfeiture, license to be seized, things of that nature, depending on whether you provide a test, and if you do, what the results are.
What do you have? Tyler, do you need to see this?
Yeah, I'd like to see it, please.
I've had this marked as plaintiff's exhibit 10 for identification, if you can tell me what that is.
This is the both front and back of the B&B 2255 form completed in reference to Mr. Walton's arrest. It was witnessed by Trooper Morton. Anytime we read this to the individual, it has to be witnessed by another person.
And is that an accurate copy of that form?
Yes, this appears to be an accurate copy.
It's a 2-page form,
Front and back, yes.
front and back. And somewhere on there, probably on the back, it explains a person, the consequences of refusing
That's correct.
to take the chemical test.
Yes,
And did he sign that? Did Mr. Wilman sign that?
he did.
I'm going to ask that Exhibit 10 be admitted.
Any objection?
No objection, Your Honor.
Be admitted.
So did Mr. Wellman agree to do a chemical test?
He did.
And let me do this first. I think I already asked Exhibit 2 to be admitted.
He did. It's been,
So what kind of chemical test did he do?
A breath test.
Where did that take place?
Postal prior, located in South.
Were you the person who actually conducted the test?
Yes, sir.
What kind of a device is used to do that test?
We utilize an intoxilizer 8000.
Are you trained to use that machine? And homework, and this is plaintiff's exhibit 11 application. Can you tell me what that is?
This is the Ohio Department of Health's Bureau of Alcohol and Tobacco, showing my certification to operate that machine with my access card that I initiated.
Did you have access to the testing machine on that day?
Yes, I did.
I'm going to ask the plaintiff's exhibit 11 to be admitted.
any objection?
No objection, Your Honor.
Be admitted.
So, are you formally trained on how to use the machine?
Yes.
I would like for you to explain, as best you can, as completely as you can, the procedure that you use in conducting a breath test with the Toxilizer 8000.
My procedure is very simple. In terms of the machine does all the work, essentially. But what I'll do, I'll start by entering preliminary information for both who the arresting officer was, myself, the time of the stop, Mr. Wellman's information, and from there, I swipe an access card, I enter my own personal PIN that I created. From that point on, the machine will ask me if the person wishes to provide a breath test. Mr. Wellman at that point indicated that he didn't want to provide a breath test. The machine does a series of checks to ensure that it's working properly. It leaves no doubt at all as to whether it is or not. Because if it's not, it's a series of beeps and tones that are quite loud to let you know, say on the screen what the issue is, what the error is.
And it also, does it print out something in writing if there's a problem?
Yes, it does.
Is that device, is that a Toxilizer 8000 connected via something, the phone line or the internet or whatever, with a central computer that is controlled by the State of Ohio Department of Health?
To my knowledge, yes. I'm not an expert on that, but to my knowledge, yes.
If there's an error that's shown, what happens to the machine?
It'll make a series of beeps that, again, are quite loud. It'll tell you on the screen what the error is. Depending on the error, there's some things that can be done, some things that cannot. I've never had an error yet that forced me not be able to continue trying to obtain a test. For example, an error that might cause an issue is there's an actual tank inside that machine to give it basically, again, this is layman's terms. I'm not an expert for the internal operations of the machine, but to my understanding, the way it's been explained to me, There's a tank inside that machine that has a gas in it, and that machine tests that gas and ensures that it's working properly. For example, if that tank was out of that gas, I can't change the tank right there. I'm not certified to do that. That's an issue that I could resolve. More common issues are, for example, like if there's a radio frequency interference, it'll have the beeps and tones that are quite loud, like I said. It'll say on screen RFI, radio frequency interference detected. And it'll immediately terminate the test. It'll print out a paper that says RFI detection or interference, whatever it is. You know, at that point, I'll ensure that there's nothing in terms of electronics that are close to the machine. I'll try it again. Another one might be an improper sample. Maybe the person didn't blow at the right time, they didn't provide enough time, they didn't do it within the 3 minutes that they had to do it. Those are just some examples, but the machine leaves no doubt whatsoever as to whether or not the test was valid. It will terminate the test right there. There's nothing else you can even do about it. I didn't have any errors indicated in this test. I had every reason that this was a valid test.
Are there some things that would cause an error that you would be able to start over again and complete the test?
Yes, so for example, the RFI detection for interference, O2O agreement, meaning that the samples were too different from each other in alcohol content, things like that nature. Proper sample, you can continue forward with that.
Are there other things then that maybe would cause the machine to shut down and say, you can take it out of service?
Yes, for example, if like that, again, this is to my knowledge, the way it's been explained to me, if that gas tank that's inside the machine ran out, I can't do anything about that at that point. I might ask for urine or something like that, but that intoxicated rate 1,000 to me would be out of service at that point.
According to the level of responsibility that you've been granted by the state of Ohio to operate the machine, is there anything wrong with this test whatsoever?
I have no reason to believe that that's the case at all.
I'm going to show you what's been marked as plaintiff's exhibit 12 for identification and ask you to identify that.
This was the Ohio Department of Health's good work on the BRAC machine and the test that I obtained from Mr. Wellman at the time. The time of the test was 134 hours, which was just slightly over an hour after the time I first observed him during the stop. His first test sample registered at a BRAC of 0.140 grams per 210 liters. His second sample registered at 0.136 grams per 210 liters. It always takes the lowest of the two tests, so that's why his official breath test is his lowest one. His second sample, 0.136 grams per 210 liters. By all, that's a violation via Ohio Revised Code.
Now, in paragraph 7 of the motion, it says that the blood, breath, urine, or other bodily substance be withdrawn within 3 hours time of the alleged violation. Did you give this test well within 3 hours?
Yes, there's a 2-hour window that I have to read that form to him by the 2255 that you referenced earlier, and there's a 3-hour window for me to actually obtain that test. I got both of those well within the time, the 2-hour time limit to just simply read it.
I want to go over some of the other particulars on this form. First of all, does your name appear on the form?
It does, as the arresting officer and the testing officer. It's on here twice.
And it says something about Claremont County.
Yes, that was my first post that I was sent to after I graduated the academy. At the time that I received that card, I was getting ready to graduate the academy. I had already had my assignment to the Batavia Post in Claremont County, and that's why my card still carries the Batavia Highway Patrol as the agency. So that's the reason for that. I can't, just for greater clarification, I cannot edit my card. I don't have that privilege or ability to do so.
I don't think I asked this before, but if you are not certified or permitted at that time to operate this machine, it wouldn't have let you in.
Correct. You need not only an access card to scan, but the PIN number for that specific access card. Without both of those, you couldn't even access the system itself.
Under the test information, It says some various things here, and I realize you're not a scientist, but can you identify what those things are to the best of your knowledge?
Could you point what you're referring to?
Well, for example, this right here, is that the testing units?
That's the serial number it appears to be for the specific intoxilizer 8000 that was utilized that night. There's a date of my last certification, or maybe the unit's last certification, excuse me. But yes, that's what it appears to be. And then has a certification model number, which again, I'm not an expert or a technician for these things, so I'd be speculating to say really much more.
But if any of that information indicated that the machine was not able to function properly because of the expiration of some fluid or something out of order, it wouldn't allow you to do the test.
Yeah, there is, like I referenced earlier, it does a series of diagnostics or diagnostic testing prior to me even being able to offer Mr. Llewellyn his first sample or any individual's first sample. If any of those failed, this machine is needed when it terminated, need further testing and say, this is not, something's wrong, this needs to be looked at. That did not happen on this night. Or I guess morning, right?
So did this test show that Mr. Llewellyn had a prohibited alcohol level for purposes of 4511.19?
Yes, it did, specifically subsections A, 1B of that. That section covers breath tests, for breath alcohol contents being between 0.080, at least 0.080, but less than 0.170 is alcohol content levels in violation of that section.
I'm going to ask the plaintiff's Exhibit 12 be admitted.
Your Honor, we would object to the admission of Exhibit 12 on the basis that the state has not laid a proper foundation, that the machine was in proper working order and certified by the Ohio Department of Health on the night in question.
Okay, I'll rule the admitted.
That's all of this witness.
All right, you may cross-examine.
Your Honor, at the outset, if I may ask the court, would it be permissible for me to do my cross-examination largely seated? I believe I've got a stress fracture in my foot.
Sure, that's fine.
Trooper Beam, thanks for being here this afternoon and answering questions. I know there are other things you need to do on Friday afternoon.
Appreciate it, thanks, sir.
All right. So I believe your original testimony was that you were alerted by the Lawrence County Sheriff's Department to a party out on 775. Is that correct?
Yes, sir.
All right. And they told you that large field party?
Yes, sir.
All right. Are you familiar with that area of 775?
What do you mean by familiar?
Okay. Did you grow up on 775? Let's start
I
there.
did not, no, sir.
Okay. Did you grow up in Lawrence County?
I did, yes, sir.
Okay. Where in Lawrence County?
Ironton area, Kitts Hill.
All right. So being an Ironton, Kitts Hill guy, did you hang out down with Fairland or Chesapeake people on 775?
I went to Rock Hill, they wouldn't let me do that.
Okay. So how familiar are you with that area of 775?
Just, I would say very generally, meaning that I drive through it when I'm working. I tell people all the time, I'm not nearly as familiar with the east side of the county. That's just not part of the county I really went to.
I understand. How often prior to this night had you patrolled that area of 775?
Just in a general sense, I mean, I'll be the first to tell you the bulk of our time is spent on US Highway 52. That's where the most traffic is, and that's where there's generally, just because of the traffic volume, more violations. So I I wouldn't say nearly as much as what I'm on US 52.
Okay. So it's fair to say then that you're more familiar with US 52 than you are with State Route 775?
Absolutely.
Okay. That night, you stated, I believe, that as you saw many vehicles passing you, right?
Yes, sir.
How many vehicles did you see passing you?
There were strings of, I would estimate up to 10 to 15 vehicles. Any state route at that time of night is highly irregular. Just knowing the general sense, like I said, I patrol the area in general, especially in inclement weather. Going out there, we'll do line checks, make sure nobody's stranded, anything like that in the cold. Going out that way, seeing the environment, the area, very rural, see that many cars coming from really nowhere I could think of, that was highly irregular.
Okay. And what types of vehicles were you seeing cross in front of you in those groups of 10 to 15?
All kinds. I mean, there's no specific kind.
Okay. Pickup truck?
Personal cars. Yeah, pickup trucks, Priuses, anything in between.
Lots of pickup trucks?
Honestly, I don't recall. I would imagine, but those are commonplace in Lawrence County. Let's say possibly, but I don't recall.
Okay. So you don't recall specifically this evening, but you'll admit that there are a number of pickup trucks in Lawrence County?
Absolutely.
Okay. And would you expect that a rural area of the county, you would have more pickup trucks than other areas?
Sure.
Okay. So as you see all these vehicles pulling out in front of you and crossing in front of your path, you stated that the vehicle that you believe Mr. Wellman was driving revved its engine, either inadvertently or for some other reason. Correct?
Yes, that's correct.
Okay. Is there anything in the Ohio Revised Code that would prevent an inadvertent revving of an engine?
No, and nor would, if I made it sound like I was saying that was a violation of law, I wasn't. I just found it to be highly irregular and interesting at the timing that it happened. But
okay. Interesting, but it wouldn't be by itself probable cause for a stop, correct?
Absolutely.
Okay. Absolutely correct. It would not be probable cause.
Correct.
All right. So when you believe you saw Mr. Wellman's vehicle pull out in front of you, you're stationary, right?
Yes, sir.
What direction is your cruiser facing when it's stationary? Because we didn't see it in the video.
So 775 runs predominantly, I mean, it's a lot of hills, so state routes are along, but predominantly north to south, if I recall correctly. I'm facing it, what would be on its west side, then westernmost side, I guess.
Okay. You're on the west side of 775. So do you recall exactly where you were stopped on 775?
I don't know what it is, but it was a big gravel lot for like, it looks like some kind of industrial facility. If you're driving northbound, I guess what would be on 775 to your left, it's only maybe a mile and a half, 2 miles out. Yeah, I don't know what it is, but I can, like if I saw it on the map or I drove by, I'd tell you exactly where I was.
Okay. Do you know the area to be commonly referred to as Wolf Creek?
I don't.
Okay. What about transformers, power substations? Was it around that area? Are you familiar with where I'm speaking of?
Yes.
Okay. So it's right in that area, right?
Yes.
All right. What's the distance between where you were and the end of 775 as you turn on to State Route 7?
I don't know. Again, I would estimate a couple of miles. I don't remember exactly what milepost it was. I don't remember.
Okay. Are there mileposts on 775?
There are.
All right. So the vehicle, there were several miles between when you first observed lines of vehicles passing you or you ultimately made contact with Mr. Wellman, correct?
Yes, sir.
All right. When you are going, I'm going to say from Wolf Creek towards Proctorville proper, okay? You understand what I say when I'm saying that?
Yes, sir.
All right. You said there's a lot of hills on 775, is that correct?
The area in general is a hill. Yes, there's winding curves, things like that.
Okay. There's hills, there's winding curves, right?
Yeah.
All right. Are there side roads that come off?
Yes.
All right. How many side roads between Wolf Creek and State Route 7? Okay. More than one?
Probably.
More than 10?
I don't know. Maybe even around there. I mean, a couple of miles deep, let's say.
Okay. So as you're going through, when you go to pull out, is it the vehicle you believe to be Mr. Wellman's passes you and you pull out immediately, or were there any other vehicles that got in front of you and Mr. Wellman?
So, just for greater clarity, as Mr. Wellman passed me, the strings of cars had started to die down. They had already been going through. As that truck passed me, it was by itself. I didn't have concern of other vehicles. But again, redirect maybe your question, sorry. Well,
Sure. Do you believe there to be any other vehicles between what you believe to be Mr. Wellman's vehicle and yours at the time you're pulling out? Did anybody else pass you?
No, sorry, no.
Okay.
That did not happen.
So is your testimony then that Mr. Wellman's vehicle passes you, you believe Mr. Wellman's vehicle passes you while you're stationary and you pull out immediately with no other vehicles?
When you say immediately, are you asking if it got out of sight before I pulled out?
Correct.
Yes, it did get out of sight before I pulled out.
Okay. So Mr. Wellman's vehicle got out of sight before it pulled out. What about at other times as you're following Mr. Wellman's vehicle? Did it get out of sight?
I think there were maybe some curves that did, yes.
Okay. And like you've already testified, that's a fairly hilly and curvy road, right?
Yes.
Okay. And in fact, there's a pretty predominant curve on 775 right before you get to State Route 7, correct?
Yes.
Okay.
Curve to the left if you're heading towards that.
Curving to the left. You know exactly what I'm talking about, where there's the gravel lot
Yes.
right off to the right.
Yes.
Okay. So you lost sight of Mr. Wellman's vehicle. Is that fair? As he approaches that intersection?
Yes, sir.
All right. So when Mr. Wellman's vehicle gets to that intersection, he makes a right-hand turn, right?
Yes, sir.
All right. But you had lost sight of it, so you don't know if Mr. Wellman's vehicle had come to a complete stop. Is that fair to say?
You're saying I lost sight of it after I got through the curve?
Prior to it going into the curve. So his vehicle goes into the curve and you lose sight of it, right?
Prior to approaching the light.
So as he's approaching the light, going into the curve, you lose sight of it, right? That predominant curve going to the left, you lose sight of the vehicle, right?
I guess I'm not clear on at what point you think I lost.
Well, I'm asking you.
Sure, okay, I guess I'm not clear on what you're asking. Maybe to answer your question, I personally watched that same truck roll through the light and I just turned signal. Does that answer your question?
Okay. Did you catch up to the vehicle to see it at a complete stop?
Yes, you can see on camera.
Okay. So you caught up to the vehicle and saw it at a complete stop?
No. I had the ability to see if it came to a complete stop. It did not.
Okay. What's the code section for failure to yield to a traffic device signal?
45, 11, 12. 45, 11, 12.
Okay. Are you permitted to turn right on red in the state of Ohio?
Yes.
Okay. And when you're turning right on red, do you have to come to a complete stop, or can you turn right if there's no traffic coming? Do you know?
You have to come to a complete stop when the signal's indicating red.
Okay. You have to come to the complete stop?
Yes, sir.
Okay. And it's your testimony that you did not see Mr. Wellman's vehicle come to a complete stop?
You did not come to a complete stop.
Okay. And you lost sight of it, but you say you caught up enough to be able to see him not come to a complete stop?
I think maybe we're saying different things, so just to clarify, when I say lose sight, it was for brief moments. I caught back up to it. I knew it was the same car. As it passed me, as it throttled, as you referenced earlier, I knew the make, knew the model, knew the color, knew that it had a West Virginia license plate on it. Tail lights were even somewhat distinct, I'd say. They're fairly dim, smaller. I knew what I was looking for. I had brief moments where it was out of my view, but predominantly, even from the video scene, you can see that truck's in front of me and in my line of sight for almost the entire time.
Okay. Let's go to the video if we don't care. This is the state's exhibit, so I apologize.
2 is the dash cam, Tyler.
2 is the dash cam?
Yeah.
Interior,
Dual view.
dual view. How far are they here? So you said your camera turns on approximately 90 seconds beforehand, right?
I activated it, and then it will include the 90 seconds that it'll ask for after that.
I apologize.
That's okay. Just clarifying.
Okay, at this point in time, is Mr. Wellman keeping his vehicle between the lines?
It's a little far from me to see right now. I apologize. There, like I said, great to see this there.
Okay, so this is the curve we're talking about, right?
This is the one you're talking about. I believe that's the one I had in mind. It's further up the roadway.
So, you don't think Mr. Wellman got to a complete stop?
No, I did not.
Okay. How do you define a complete stop under the Ohio Arrest Code?
A complete stop when you tell that vehicle is no longer in motion. That vehicle never ceases motion.
So it has to come to a stop at the traffic indicator, right?
Yes.
Okay. So, and your testimony is you don't believe it came to a complete stop?
No, it did go to a complete stop.
All right. After you had him pull over, you said you made a passenger side approach?
Yes, sir.
All right. When you made that passenger side approach, is there anything distinctive about the height of Mr. Wellman's vehicle?
Like any truck, it's that size. Some of them have a natural lift to them, some of them have lift kits in them. This was a little higher than you might typically see, but all, it's set up higher off the ground, especially compared to a normal passenger car.
Okay. And when you make that passenger side approach, is it fair to say that the truck sits about chest level to you? The bottom of the window?
Yeah.
Okay. And from that vantage point, when you approach, were the lights on or off inside the cab?
Inside his cab?
Mm-hmm.
I don't recall.
Okay. If the lights were off, would you be able to determine anything about his eyes?
I use my own flashlight. That's
Okay.
generally how I'm inspecting someone's eyes.
Okay. So you take your flashlight and you shine it into somebody's eyes?
Not directly. I mean, I illuminate the inside of the vehicle with my flashlight. It's generally pointing in the downward direction, generally.
Okay. So with the vehicle being above you, how can you point it down into the cab?
Hold up here just like I do for like standard field sobriety tests. I'm doing horizontal gaze nystagmus. So I have my light all the way up here with the flashlight. I actually stand it up on the end so that they don't have any part of the beam directly pointed at them. I kind of use the palm of my hand to illuminate their face. Same thing. Hold up higher, point the flashlight down.
Okay. All right. And your testimony is that you were able to see watery bloodshot eyes from Mr. Wellman?
Yes, sir.
All right. Where you were standing, did Mr. Wellman have to lean over to see you, or could you look straight on at him? Okay. You stated you smelled the odor of alcoholic beverage, but there was Mr. Wellman's significant other between you and he, is that correct?
Yes, sir.
All right. Did you ask her if she'd been drinking?
Initially, I don't believe so. I only asked him.
Okay. All right. Let's talk a second about that stop. The reason you pulled Mr. Wellman over was for failure to come to a complete stop, correct?
That was one of the violations that I witnessed.
Okay, but you told him you only pulled him over because he failed to come to a complete stop. Fair to say?
I did say that was, the reason for the stop.
Okay, you didn't cite him with anything other than failure to yield to a traffic control device, correct?
Correct.
All right. So, you didn't tell him that he was being pulled over for anything else. You didn't cite him for anything else, correct?
Correct.
Okay. So it's fair to
At
say.
least at that point, after the arrest, I talked to him about his speed and things like that. If I recall right.
Okay. But it's fair to say that at the time you made the stop because of the traffic control failure to yield.
No, I mean, prior to even when you activated my overhead lights, you can hear me articulate what I'm saying. I'm not required to cite anybody for everything that I've observed, but you can hear me clearly articulate that prior to even stopping it.
Okay. Let's talk about your NHTSA certification. How often do you have to be recertified on NHTSA standardized field sobriety testing?
Recertified?
Mm-hmm.
I don't believe I have to be recertified.
Okay. How often do you have to undergo refresher training? Let me ask a better question.
How long?
Okay. So you agree with me that you are required to undergo refresher training?
No, I'm saying I don't know.
Okay. So you don't know if you have to undergo refresher training or not?
It's possible it's required. If it is, I don't know the statutes on how frequently, how often, or what that entails. Do we get refresher training? Yes. Sometimes it's just an online document, but I think one of the biggest things that's understood too is how often, especially night shifters, are administering these tests.
Okay. So it's possible you're required to undergo refresher training, right?
It's possible. I don't know.
Okay. And then it also would flow logically that if you're required to undergo refresher training, you haven't done so, you could potentially be out of compliance with the NHTSA manual, correct?
Using that logic, yes. However, the state of July is not tired. Set of experts and legal personnel that ensure that we are getting the training we need when we need it. I say with confidence that if that is required, I'm getting it as I'm needing it to maintain my certification. But again, I don't know if that is required.
So as we sit here today, you don't know whether or not you were properly certified at the time with a refresher training?
No, I wouldn't agree with that.
Okay. You don't know, but you won't agree with it?
I'm saying that I have every confidence that I was qualified to conduct standard sobriety testing at that time.
Okay. And is your confidence based off of the number of DUI, OVI, DWI stops, however we want to refer to them, or is it based off of your refresher trainings?
It is based on the fact, neither of the ones you mentioned, it's based on the fact that the State Patrol does a top-notch job of ensuring that we are qualified to do the job that they've asked us to do.
Okay. When was the last time you actually had a refresher training? Have you had a refresher training since you left the academy?
We've had the 2023 update. Is it in terms of actual refresher training? I don't recall. We have so many trainings. I get probably, I don't know, 10, 15 trainings a quarter, whether it be online or in person, on various things. It's after 3 years, it's hard to keep track of everything like that.
Okay. At the time you made the traffic stop on Mr. Wellman for failure to make that turn, was he being detained or was he free to go?
It was a probable cause stop.
It was a problem, okay. Was he permitted to leave if he wanted to at that point?
No.
Okay. So is it fair to say that if he had left, you would have charged him with fleeing and evading an officer?
Yes.
Okay. How many seconds passed between the stop and you asking Mr. Wellman about drinking?
I don't know.
Okay. But you did ask him about drinking, correct?
I did.
All right. Did you Mirandize him before you asked him about drinking?
I did not.
All right. Did you ask Mr. Wellman if he had any speech issues or impediments?
No.
All right. You stated that you thought he was slurring his words when you first made contact with him. Do you recall that testimony?
Well, not that I thought. I observed his speech to be irregular.
Okay.
It's possible.
Okay. So as we sit here, it was just a speech irregularity. It wasn't a slurring of words, correct?
So when I am considering speech impairment, whether it be slurred, lethargic, low and raspy, things like that, I'm looking at the totality of the circumstances. Sure, somebody can misspeak. That's possible. I understand that. But I don't base that on that one single thing. I have 2 left of center violations. I have somebody speeding at a decent rate of speed through 45s, and I have somebody who did not come to a complete stop. They failed to use their turn signal. There's an odor of an alcoholic beverage emitting from the vehicle. There are eyes of water and bloodshot that admitted to consuming alcohol. I'm not going to omit or assume that speech is a coincidence either. To me, that is a pure speech.
You've had training on, you talked about touching the lines. In the 4th District, is it probable cause to stop a vehicle for touching a line, or does the one width of the tire actually have to go over the line?
I don't know what the 4th District's ruled. I know that based on the ORC, you have a left of center violation. If you have 2 double lines, right? Mm-hmm. Right in between those 2 lines is the center point of the roadway. So that means if I've driven on the other side, the second line, I'm left of center at that point.
Okay. So if I understand your testimony correctly, I've got a double yellow in the middle of the road, right?
Yes.
If my tire touches the inside yellow to where I'm driving, I'm okay, correct?
Not the inside, the outside.
Okay. So as soon as I touch that line, you consider that a left of center violation?
It's left of center. They're left of center at that point. They're outside of their lane.
Okay. So the strip between the double yellow line is the center point of the roadway, right?
It has to be, right?
Okay, has to be. But if I touch that inside line, you're saying that's also a left of center violation, even though that's not the center of the roadway by your own testimony.
I think that I understand what you're calling inside line, but I don't understand. Are you talking about the yellow line closest to the vehicle?
I am.
Mr. Wellman did not only drive on that one, he drove on the one to the outside, then, is what you'd be calling it, I assume.
Okay. Trooper Beam, what's your vision? Do you know?
2020.
Okay, when was the last time you had your vision checked?
Right before I got in the academy.
Okay.
Actually, no, I'm sorry, I had a physical for the patrol in August of this past year. I checked my vision then, still good, 2020.
Still 2020. All right. At what point, describe the terrain when you saw Mr. Wellman's vehicle cross left of center as you believe?
Relatively flat. I think, I don't remember exactly, I have to look at the video again, but I believe the second time it was some of the curve, I made mention of, maybe it's the first time, it made mention of the braking sequence too. Some of the curve.
Okay. And isn't it common that people have to slow down going into a curve?
At 45-mile-an-hour zone, you shouldn't have to slow down for a curve that's not that steep, right? Or I say steep, sharp of a curve.
Okay.
How many curves do you go through daily that you never brake for? You know what I mean?
I break into every curve.
Every curve?
Yeah.
Better than me.
Okay. So you didn't Mirandize him, you didn't ask about any speech issues or impediments. You didn't do the vertical gaze nystagmus because you didn't believe you needed to, correct?
It's not a matter of need to me, it's a matter of, this is going to help me make my decision to arrest.
Okay. Is vertical gaze nystagmus part of the standardized field sobriety testing, however?
Yes, it is.
Okay. So you chose not to do a required test?
Not required, it is part of the standard field sobriety testing. It'd be no different than somebody just simply refusing to do a long-term or one-night stand test.
I'm sorry, you said that's no different than somebody refusing to do one of those tests?
You have the manual, and then you have what they're willing to do, right, in terms of testing. I can make the decision to arrest without performing those tests.
Okay. NHTSA says that, how many steps does NHTSA say there are in a pre-arrest screening prior to the arrest decision?
How many steps? I guess I don't understand.
Okay.
Or no.
If we start with the initial observation of vehicle operation and end with a preliminary breath test, and we call the initial observation number 1 and the PBT numbers the last, yeah.
The tasks?
Yeah.
You have 2 in each phase, there's 3 phases, so 6 total.
Okay.
2 tasks per phase, so 6 tasks.
So you have the initial operation of the vehicle, correct?
So yeah, vehicle motions phase 1.
Okay, what's the second?
Phase 2 is personal contact.
Is it personal contact or is it observation of the stop?
Are we talking about tasks or phases? I'm talking about phases. Phase 2 is personal contact.
Okay, I'm going to represent to you that the NHTSA manual says that there's initial operation of the vehicle, correct?
Okay, so you're talking about tasks. For vehicle in motion, there's 2 tasks. The first is initial observation of the vehicle, and then observing the stopping sequence.
Okay, and then there's a face-to-face observation and interview, right?
Yes.
Okay, and then there's an observation of the exit.
Correct.
Okay, was there any issue with Mr. Wellman as he exited the vehicle?
Not that I observed, no.
Okay, but that goes into your arrest decision for impaired driving, right?
What do you mean by that?
Okay, so NHTSA trains that for an arrest decision, one of the things you look at is the observation of the exit from the vehicle, correct?
Yes.
And you noted nothing wrong with his exit from the vehicle, correct?
Correct.
All right. So then you proceed on to the standardized field sobriety testing, right?
Yes.
And then you'll perform a PBT.
Yes.
And after that, you'll make a decision as to whether or not to arrest an individual. Is that correct?
Yes.
All right. So when we talk about the horizontal gaze nystagmus, there are generally 10 things you look for in the procedures. Is that correct? 10 things you do, 10 things you look for.
I don't know the exact number.
Okay. So I'm going to tell you, number 1 is check for eyeglasses. What's number 2?
For procedurally?
Mm-hmm.
So I don't do a breakdown in terms of numbers for what you're looking for. I'm actually checking a box that I have to check as I do. I don't have a number that I'm looking for.
Well, how do you, if you don't know the numbers and you're testifying that you're checking boxes, how are you checking boxes if you don't know the procedures?
Okay, when I say checking boxes, what I'm talking about is, am I substantially compliant with what they've asked me to do? You could break that, with your question, you could break down what you did for one, specifically word for word say, for example, walking turn test. You didn't say word for word to do this. You didn't say word for word to do this. I can knock out several of those steps in one single statement.
Okay. So is it fair to say you don't know the horizontal gaze nystagmus procedures as they're outlined in the NHTSA manual?
I know what's expected of me for that horizontal gaze nystagmus test.
Okay, so what's expected?
So I'm, for one, again, the preliminary questions that help me check some of those boxes. Or contact lenses or glasses, did you need them? And some of these questions cover all the testing, but in terms of horizontal gaze nystagmus, things like that, I'm looking for track, their pupils equal in size, do they track equally? Is arresting nystagmus present? I'm looking for the clues that are validated as part of that test.
Okay.
Are they standing with their feet together, hands down on their side? Are they in a position where I can conduct appropriately?
Okay. So what are the 3 clues of the horizontal gaze nystagmus test?
Lack of smooth pursuit,
Okay.
distinct and sustained nystagmus, maximum deviation, and onset of nystagmus prior to 45 degrees.
Okay. So when we talk about the mechanics of clue number 1,
Yes.
right? How many number of passes are you required to do on a horizontal gaze nystagmus?
For lack of smooth pursuit, or all 3?
For lack of smooth pursuit.
2.
Okay. And what is the time frame that you're supposed to go from center, to bring the eye from center to side?
2 seconds.
Okay. And when you get out after that 2-second mark, how long are you supposed to hold at maximum deviation?
We're talking about lack of smooth pursuit or maximum deviation?
I'm now moving into maximum deviation. So when you take it and you hold it out here, how long are you supposed to hold?
At least 4, maximum of 30.
Okay. And you marked here that Mr. Wellman had distinct nystagmus at maximum deviation, correct?
Yes, sir.
Okay. And what does that mean?
So again, nystagmus is referring to the involuntary jerking of the eyes. I talked about this just a little bit earlier. As I'm holding that out, if they're not impaired by the 3 drug categories that I mentioned, or there's no other abnormalities observed, it's within 88% accuracy. This person will exhibit that nystagmus. So as they're looking out at it, their eyes will involuntarily jerk. When they're impaired by those substances, the eyes want to go back to center of focus. So, persons impaired by those substances over that limit, for alcohol, 0.080 or greater, as they're looking out here, their eyes jerk back to center. If you're not impaired by that, your eyes are just looking right at it. You can get into fatigue, but that's why we terminate that at 30 seconds.
Okay. How long before the onset of fatigue?
Well, I'm sorry, I don't understand your question.
You said that one of the things that, I believe, if I understand your testimony correctly, if we're holding out here, there can be eye fatigue that causes an involuntary jerking of the eyes, correct?
Correct.
How long before fatigue sets in?
Fatigue becomes a concern at 30 seconds, or greater than 30 seconds.
Okay. Is that a general principle, or is that, true for everybody?
I imagine everyone's different. This is done in a standardized test that was done using a scientific method. San Diego study in 1998. They found that, I guess I won't speak too much of the findings. I wasn't there present or anything like that. But fatigue in general is not a concern.
Okay. You keep referring to the San Diego study that was done, right? That's part of your testimony here today. A great part of it, right?
Yes, sir.
All right. The San Diego testing that you keep referencing, they made a determination related to a percentage that indicated impairment of above 0.08. What was that percentage?
For horizontal gaze nystagmus?
Generally, for the standardized field sobriety testing.
If I've observed all 3, the 3 phases, horizontal gaze nystagmus, walking through one leg stand, if I have the minimum amount of clues for all 3 of those, there's a 91% likelihood and accuracy that this person is impaired, specifically with breath and alcohol content of 0.080 or greater.
Okay. You said 91%. You say that with great certainty. All right.
Not with certainty, I'm just telling you what that study found.
Okay. Have you reviewed the study?
I have not read it in depth, no.
Okay.
I just know that that's the basis for which it's manual.
Okay. Were you taught that it was 91%, or where did that number come from?
So it's included in the manual, as well as it's part of instruction, yes.
Okay. It's included in the manual that it's 91%.
It's 91% accuracy.
Okay. Where in the manual?
I don't know the page number.
Okay. If I represented to you that it's actually 88%, that'd be different than what you've testified to, right?
Okay, again, I asked earlier if you're talking about the horizontal gaze nystagmus test.
I'm talking about the entirety of the San Diego study and how effective standardized field sobriety testing is, not just horizontal gaze nystagmus.
Okay, so my understanding, and in the manual, it says that if you have the minimum amount of clues for HDM, walk and turn, one leg stand, it's a 91% accuracy, you can say that person's impaired.
Okay. So I disagree with you about the 91%, but we won't quibble over it.
Okay.
But there is a chance then that, not a chance, by its own study, the San Diego study, standardized field sobriety testing is not foolproof perfect, correct?
I have no part in that. I don't feel like I can even speak to that.
Okay. So you'll agree with me 91% is not 100?
It is not 100, no.
All right. So it's not always 100% effective, fair?
It's not 100, right? It's 91%.
Okay. Okay. So I'll take you back to when you first made contact with Mr. Wellman. So one of the things we talk about is you start asking him, take his hat off. You recall that?
Yes.
All right. He immediately stated, do you want me to empty my pockets? Do you recall that?
Yes.
All right. So you guys are having a conversation and you're giving him tasks to do at the same time, right? And I believe you called this divided attention?
Yes.
Okay. Would you agree with me that having a conversation with you and him having the presence of mind to ask about things in his pocket would also be indicative of not having divided attention?
Could you clarify for me?
Sure. He asked you about a pocket knife and a chapstick specifically in his pocket. You recall that?
Yes.
Okay. Would somebody having the presence of mind to ask about those things and to not put their hands in their pockets with an officer, would that be indicative that they're probably not impaired?
No.
Okay. Would you agree with me though that a person asking those questions while you're talking to them and asking them to do things shows not divided attention, not a lack of divided attention, but the ability to actually have divided attention?
That's not remarkable in and of itself. You have to consider it two items in his pocket. I can tell you what I have in my pockets, inebriated or not.
Okay. You talked about the requirements for doing the horizontal gaze nystagmus as well as the walk and turn test. What are the requirements in terms of the roadway?
For the walk and turn test, you said?
Horizontal gaze nystagmus and walk and turn.
Relatively flat, solid surface, without an incline, things of that nature. It needs to be a situation in which they can do the test without fear of falling, essentially. You don't want to put them in harm's way, put them around trip hazards, things like that.
Okay. You want to make sure the test is not done in vicinity to close proximity to traffic, correct?
Within reason, yes.
Okay. And how do you define within reason?
There's some roadways, like a state route, for example, like we talked about earlier, 775, they don't even really have a shoulder. I mean, you might have like a couple inches on each side of the way fault lines. I'm not going to have them do it in the roadway unless, on night shift, especially on a state route, if I'm out in Waterloo, you might not have a car pass that entire time. I'll have my lights on. I'll make sure that the roadway's illuminated. I would use the roadway at that point, but in this case, there was a shoulder, substantially large one. You can see there, he's got a large truck and he's got decent room on both sides. There's within reason.
Okay. And but there is traffic passing up and down State Route 7
Yes.
by you guys while you're doing this, right?
Yes.
Okay. And is it fair to say that if there's traffic passing beside you while you're attempting to do these tests, it can divide your attention?
Why would it divide your attention?
Okay. Well, so for instance, if somebody's worried about getting hit by a car while also listening to your instructions, you can understand the concern with getting hit by a car, right?
So my car was positioned right there between us. I have my rear deck on, meaning that my rear lights on my light bar are activated. I almost think that from my observations, most people almost have like, a very at ease location like that. I've never once had anybody in the entire time I've done standard sobriety testing voice concerns with traffic passing or their security during testing.
Okay. Has anybody told you, so nobody's ever told you that they're concerned about a car hitting them, right?
Correct.
Okay. Can you understand how somebody might have some concerns about being hit by a vehicle on a busy state route?
I mean, I have that concern just driving to get groceries. I mean,
okay. You have that concern while you're performing standardized field sobriety testing, right?
Of course, I mean, I have my rear deck on, right? I want to make sure it's a safe place for me as well. We're all trying to get home.
Okay. One of the things that you've marked here on the walk and turn, you said that he moved his feet to keep balance while listening to instructions, right?
Yes.
Okay. What exactly does that mean to be an indicative clue? Like, what's the line? So if I'm standing there and I'm talking to you, and I've got back problems and I'm kind of shuffling, is that I'm moving my feet while listening to instructions?
For one, if you had back problems or something of that nature, I'd ask follow-up questions. So maybe that's, to me, each person is different. You'd referenced that earlier, right? Fatigue, maybe, your argument was maybe fatigue is different for the timeline. It's going to be a person-to-person basis. Mr. Wellman didn't indicate that he had any concerns of his own. If he's not telling me anything he's concerned about, I'm not concerned about any physical issues. In terms of the line that you're asking me about, imagining a straight line, if you've ever scribbled anything on paper when you're a kid or drawn something on paper, we all imagine something put on paper, drawing a line is one of the first things you probably learn how to do. It's not difficult. For that reason, I'd imagine that's why it's part of the standards of field sobriety testing is we're not asking anybody to do anything difficult. It's not about figuring out intellect. I'm trying to figure out if somebody's impaired. So in this case, yes, I'm asking them to imagine a straight line. It's anybody can imagine their foot on a line, they're touching heel to toe. The moment that they break that line, imaginary or not, that's a clue that's been observed.
Okay. So when we talk about instructions, did you give Mr. Wellman the instruction, do not move while I give you these instructions?
I told him I don't want him to move until I told him to begin.
Okay. But did you tell him did you say, hey, don't move at all while I'm giving you instructions, or did you say, just don't move while I'm giving you instructions, meaning don't perform the test while I'm giving you instructions?
I didn't specify. So what that means is if I say don't move until I told you to begin, don't move until I told you to begin.
Okay. All right. What about his turn was incorrect?
So the way they're instructed, I say keep your front foot touching the ground, you feel like turn yourself around with a series of small steps. And I demonstrated that for him. For Mr. Wellman, he almost pivots both feet without even taking a series of small steps. Not what I told him to do. He said he understood what I asked him to do. That's a validated clue that's observed.
Okay. Would an object that prevents him from taking a series of small steps, is it possible that there's an object that can prevent him from taking a series of small steps as instructed?
I already analyzed the roadway. I had no concerns with any objects preventing him from being able to do that. If I did observe that, it would have been moved, or I would have asked him to stand somewhere different for the testing. I had no concerns.
Okay. So let's talk about that.
Okay.
Is this your body cam? Do you have one for us?
Number one is
Yes,
the body
sir.
cam.
Yes, sir, that's right.
You got it? Any questions for me? You understand we make the inside?
All right, so a little difficult to see exactly right here. I'm going to try because this is not precise.
Any questions for me? You understand we make the inside?
All right, so at that point, is he standing heel to toe in accordance with your instructions?
Yes.
All right. Now, count the steps for me.
1, 2, 3, 4, 5, 6, 7, 8, 9.
So he's taking 9 steps right there, correct?
You can continue.
Okay.
10.
So he's trying to pivot, as you told him, correct?
I did not tell him to pivot. I told him to take a series of small steps, turn himself around using his other foot.
And to remain on a straight line the entire time, right?
I told him to keep his foot touching the ground.
Okay. So
His front foot touching the ground.
if my front foot is touching the ground and I'm turning around, doesn't that require me to pivot?
I did not instruct him to pivot.
Okay. How do you expect him to keep his front foot on the ground and turn around without pivoting?
So we rewind it and I can maybe talk through it a little bit here.
This is all from the table. You know, just like, let's shoot the good. Let's shoot the good. Any questions for me? You understand we make the inside?
He's doing a pretty good job staying on a straight line, isn't he?
He did not step off line. So even if, you're calling it a pivot, we're getting into maybe semantics there, he turned around on his back foot, that's the opposite of what I told him to do.
Okay, but his front foot remained in contact with the ground, didn't it?
Wait, what?
You said you wanted his front foot to stay in contact with the ground as he pivoted, right?
So, do you understand what I'm saying? He didn't take a series of small steps to turn himself around like.
Okay, so which was it? Did you want him to take a series of small steps, or did you want him to keep his front foot in contact with the ground?
I wanted him to keep his front foot touching the ground and his other foot to turn himself around a series of small steps. He did not.
So you wanted him to do like this? Do the hokey pokey?
No, I didn't demonstrate it for him.
Okay. So as he comes back, let's count his steps. All right? I believe this is probably step 1, he's already in the middle.
Could you have maybe back 10 seconds so I can count? You just like the back 10 seconds.
Any questions on what you do? Just make sure you keep your hand.
So again, that front foot is at the hood of your vehicle, and you want him to stay on that foot and pivot while it's at the hood of your vehicle.
That was adequate for him to have been able to do that.
Okay, how many steps did you take?
9 steps.
All right. How many steps did you tell him to take?
9 steps.
All right, so you say he took 10 steps going down, including the step to turn.
That was a 10th step. He didn't even attempt to turn until after 10th step.
So he follows a straight line down, he follows a straight line back. You agree with me on that, right?
Yes, he did not step off.
All right. So your belief is you marked incorrect number of steps because you think he took a 10th step while he's turning after you've told him to take a series of small steps.
He took his 10 steps and then attempted to turn.
Okay. So if, for the sake of argument, if there's not an incorrect number of steps, and if he doesn't turn incorrectly, how many clues do you believe he has?
Well, based on his performance, he had 3. I mean, it's...
You marked 3, right? But I'm saying if we took away incorrect number of steps and turning incorrectly, that's 2 of your 3 clues, right? If we took those off, hypothetically...
Hypothetically, in a what-if world, if you subtracted 2 from 3, you have 1.
Okay. How many clues do you need for proof of impairment under the walk and turn?
It's believed 79% accuracy that taking 2 clues of the 8 or more indicates with accuracy that they are there.
79% accuracy?
Yes, sir.
Okay. And where's that 79% number come from?
San Diego study, reiterated in its manual.
Okay. The study you haven't reviewed?
The study that I was instructed of the findings of in general with its manual and its training.
All right. So you stated that Mr. Wellman swayed while balancing?
Yes.
Okay.
Referring to the one leg stand now?
I am referring to the one leg stand.
Okay.
All right. So what do you define as swaying while trying to balance?
Considerable sway of 3 inches.
A considerable sway of 3 inches?
It's an observed sway of 3 inches.
Okay. So let's look at this and I want you to tell me where Mr. Wellman starts to sway. Actually, before we get there, what about boots? You stated that you have a pair of boots similar to what he has, correct?
Yes.
Okay. If you were given the opportunity to do a walk and turn in those boots, would you want to do them in those boots?
No, but I probably put my boots on once every 3 months, so I'm not comfortable with them. He's wearing them out, maybe, I don't know how often he wears them. He told me he's comfortable. I don't know what's wrong with him.
He also asked you to put on his tennis shoes, did he not?
He did.
And you told him he couldn't put them on?
He said that he couldn't put them on, yes.
He asked you to put them on, didn't he?
If he asked me, I told him I wasn't going to do that. We're on the side of the road. I'm not going to do a word or change. He can do it with his boots off, but it was brought up. I told him that.
Okay. So the options are you can either take the boots off, walk on the roadway, where there's pebbles, impediments, all sorts of things, or you can do them with the boots on, right? Those are the options you gave?
He had the option, he opted to keep them on.
Okay. So less than optimal footwear for the test. You'll agree with that?
I wouldn't say that. I would agree that my personal choice wouldn't be that, but that's because I hardly ever wear mine.
Hey, Tyler, next thing I ask you, this is going to be the last thing I ask you, just take the keys together for me, please. Take it down to your side, don't begin until I tell you.
So right now, he's doing everything you're telling him to do, correct?
With those instructions I just gave him, yes.
All right.
You understand? What I'm going to ask you to do on this one is take a finger of your choice, left or right one. It's you take that one of your choice, hold approximately 6 inches above the ground, and parallel with the ground like mine is. Both legs nice and straight, no bend in your knee. Keep your hands down to your side, but down to your toe, not just yet.
Okay. Prior to him lifting that foot, had you told him not to lift his foot?
I told him not to move until I told him to begin.
Okay. So let's rewind to make sure. Here's that main broken computer.
Before we ask any questions for me, you understand you make kids out there? We ask you to just stick your feet together for me, please.
Okay, stand with your feet together with me. Did you tell him to move, or that he couldn't move?
I haven't given the full instruction yet.
Okay, so at this point, you've not told him he can't move, correct?
At this point.
Hands down to your stomach, don't begin until I told you to, you understand? What I'm asking you on this one is take a foot of your choice, left or right one, it's totally up to you. Take that one of your choice, hold approximately 6 inches above the ground, and parallel with the ground like mine is. Both legs nice and straight, no bend in your knee. Keep your hands down to your side, but down to your toe, not just yet. Not just yet. You put your foot down, I'll tell you when. With your hands on your side, down to your toe, count a series of 1,000s like so. 1001, 1002, 1003, 1004, and so on as I go.
Okay, did you tell him to count out loud, or did you say count a series of 1,000s?
That's what it means. Yes, I said count a series of 1,000s like so. 1001, 1002, 1003, 1000.
Have you ever done a modified wrong word test?
Like it's been conducted on me, or have I performed?
Are you familiar with the modified wrong
Yes,
word test?
yes.
All right, in the modified wrong word test, do you tell somebody to count or estimate the passage of 30 seconds out loud or in their head?
In there.
And do you tell them to estimate in the head because that's a clear instruction, right?
I guess I never really thought about it. I mean, just the way I was trained to do it, so that's what I did.
Okay. So you understand if you don't tell somebody to count out loud, they may think they can count in their head. You understand that, right?
I told him to do it exactly as I said, just like I do, like so. He did not do that.
Okay. Okay.
I'll just show you boots off for all the straight, no bend in your knee. Keep your hands down to your side, but down to your toe, not just yet. Not just yet. You put your foot down, I'll tell you when. With your hands on your side, down to your toe, count a series of 1,000s like so. 1001, 1002, 1003, 1004, and so on as I told you to stop. Does that make sense? Any questions for me? You understand the instructions, Tyler?
Okay. Did you ever tell him how long you needed to maintain his foot?
No.
In the air?
No.
Okay.
You mean,
Did you tell him he needed to keep his foot up 30 seconds?
I did not say 30 seconds, no. I did tell him not to stop.
You may begin. Get down to your toe there. You pick it up as where you left off.
Where's the swing?
Watch it start to go down there.
Is that swing or putting his foot in?
Yeah.
I mean, you can do both simultaneously.
Okay, was he swaying side to side?
Towards any side. It doesn't say it has to be both left and right. You can sway towards one direction, right?
When your testimony is swaying is moving 3 inches, which way did he move 3 inches?
Towards the left.
Okay, under the NHTSA manual, is the swaying an upper body sway or is it sway of the foot?
It's upper body sway.
Okay, so where's his upper body sway?
To his left as he put his foot down. It's a gradual movement. It doesn't have to be a jerk or anything like that. It can be a slow process for that matter. But if he swayed towards one side, kind of 3 inches.
So it's officer discretion. Is that fair?
No.
Okay. Well, you make the discretion of whether or not to mark it, right?
Yeah. I report observations. You make it sound as if I assume you meant that it's on the whim of what I determined at the time and the way I'm feeling. It doesn't work like that. It's based on observations. Do you do it anytime you do it?
Okay. You agree with me that different people can have different observations, right?
Well, that's why this is standardized, right? We're given a certain set of rules that we're supposed to.
You stand right by the
So you marked him for putting the foot down because you said, "Are you done?" He said yes, and you said, "Okay." So you didn't tell him you needed to put it back up for 30 seconds or redo the test. You just said, "Okay, you're done," right?
I asked him if he was done. He's not required to do anything that I asked him to do on that. That's it. If he says he's done, he's done.
So if he's not swaying, he doesn't put his foot down, hypothetically, and those things are removed from your observation report, is it indicated that he's impaired, or is it indicated that he's passed the one-leg stand test?
So hypothetically speaking, if you're saying that you removed the 2 clues that I observed from the ones that I reported, that would be a total of 0 clues.
Okay.
That is not what I observed, but hypothetically, yes.
All right. When did you first come into contact and observe Mr. Wellman?
Personally, like when I'm,
What time?
I don't know the exact time.
Okay. Was that noted in your report?
The time of stop, I don't know if it was in my report. Generally, I'll put the time of the stop. I don't put the time of when I first got face to face with him.
Okay. Is there anywhere you mark your first observation of a person?
Personally, like person to person, just for my clarification.
Sure. When you're reporting on an OVI, is there any place where you mark the time you first observed somebody?
So the time of observation, you know, that the process starts with the vehicle in motion, right? So that's when the time of observation begins.
Okay. So your testimony then is the first time you saw his vehicle passing you when he revved the engine, that's the time of first observation?
Are you asking, what are you asking? Are you asking me what time did I first make eye contact with Mr. Wellman, or are you asking me what time the sequence began?
My question was, what time did you first make eye contact with Mr. Wellman?
I told you I don't know.
Okay. So when you mark down for the arrest information, you say time first observed, and it's 0025. That's 25 minutes after midnight, right?
Yes.
Okay. Is that the time you first observed the vehicle, or the time you first observed Mr. Wellman?
That's the time the traffic stop was initiated.
Okay. All right. And where it says here time of test, what is the time of test? Does that mean the time that you started your standardized field sobriety testing, or is that the time that you had Mr. Wellman utilize an intoxilizer?
The latter, the time that you utilize the intoxilizer. That is the time captured by that device and recorded on that.
What is the time period that you were required to observe Mr. Wellman prior to administering an intoxilizer?
20 minutes.
All right. How much time passed between observation and test?
I don't know. I can tell you this is well beyond 20 minutes.
Okay. And as part of your NHTSA training, are you trained what happens with somebody consuming alcohol in terms of intoxication?
With respect to mouth alcohol?
Generally. Let's start generally and then we'll go to mouth alcohol.
So can you repeat your question then?
Sure. What happens when somebody drinks alcohol? Let me ask a better question. If somebody drinks alcohol, are they immediately impaired? Do they have some level of alcohol in their system, or somewhere in between?
So it has to be absorbed by the body. That's how it gets into your bloodstream, right?
Okay.
So, that's one of the things that troopers talk about sometimes when we're talking about impaired drivers is, are they going up or are they going down? That's our speak for, is their alcohol content in their blood or breath still rising, or is their body metabolizing it out and they've had enough time to start? Obviously metabolizing it, but has it stopped being introduced and their breath alcohol content is now going down? Because there's times where, hey, say maybe somebody just left the bar in Huntington, I stop them, and they can still be going up if they pounded a couple of beers right before they left. That would be what we're referring to when going up. So it has to be absorbed by the body. There's a certain amount of time that it takes for the body to metabolize it, process it all. I think that the general consensus in general is 0.015 grams per 210 liters. The body processes it out per hour.
Okay, per hour?
Yes.
All right. So when you saw Mr. Wellman for the first time, do you know for a fact that he was coming from the party on 775?
No, he was coming from that direction.
Okay. How fast between when you saw him and when you stopped him? Was it hours? Minutes, seconds?
No, sorry. No, I understand what you're asking now. No, it wasn't minutes, right?
Okay.
Yeah.
All right, so to use trooper speak, was he going up or going down?
I don't know, we can't always tell that. That's, when we talk about that, it's kind of like, I think he was still going up, or I think he was still going down. There's a whole list of people who have expertise in analyzing that. We have DREs, and they can even evaluate, approximate, or make an assessment of what their breath alcohol content is based on how soon they see the onset of nystagmus or HGN. That's not something that I've been certified to do, so I'm qualified to answer if he was going up or down at that time.
Okay. Based off your personal observation, do you believe he's going up or down?
I don't know. I really don't know. It doesn't play a factor in whether or not I think they're impaired. I make an assessment as to whether they're impaired or not at that time. It's not whether, even if I thought they're going up or down, that doesn't have any sway in my assessment at that time.
Okay, but it plays a factor into how fast the alcohol metabolizes and what their breath score would be, does it not?
It can, I mean, to my very basic understanding, without being an expert, like I said, I'm not a drug recognition expert, up or down is one of those things that is mentioned.
Okay. How much breath volume is the minimum breath volume that's required for the Intoxilizer 8000?
I don't recall about that.
If I represent to you that it's 1.1 liters is minimum breath volume, do you have any reason to disagree with it?
I need to agree or disagree, I don't remember.
Okay. Assuming that a minimum sample size is required to be 1.1 liters, okay, that means that that's the minimum amount of breath expelled into the machine to get an accurate reading, correct?
So again, I don't remember how much it requires. The machine does tell me if it has had a sufficient sample.
Okay. And when it tells you that it has a sufficient sample, does it light up and say sufficient sample given stop, or does it just say sufficient sample, or does it, you have them blow and after they stop, they'll either say insufficient or sufficient?
It doesn't. So the big alert comes if it's not. That's when you get the errors that I talked about earlier with the beeping and loud noises, and it immediately terminates everything. If it's not done within a certain amount of time, or there's been too many attempts to do it.
Okay. So if I represent to you that 1.1 liters is the minimum sample size, right? Do you recall what the first sample size was for Mr. Wellman?
No.
This is what the state handed me as my copy, so I'm going to ask for it back for me. What was the first liter sample size for Mr. Wellman?
2.964 liters according to this paper.
Okay, so almost 3 times the 1.1 liter
I'm going to
sample size,
object
right?
that there's been no evidence presented as to what the minimum sample size is.
I'm asking hypothetically, Your Honor.
I'll let him,
Okay.
how much longer are we going to be on this, Mr. President?
Just a few more questions, Your Honor. Almost
Okay.
finished.
All right. Continue.
So almost 3 times the minimum sample size is what I represent as the minimum sample size.
Based on, yes, your number, that would be nearly 3 times.
Okay. What about the second breath sample? What was that one?
2.656 liters.
Okay. So a little over 2.5 times the minimum sample size, right?
Rough estimate math, yes.
Okay. What happens if you give a breath volume sample in excess? Let me rephrase it. Does the blood alcohol content as measured by the breath in the Intoxilizer 8000, does it go up as you provide more breath volume, or does it go down?
So, I don't know. Basically, the way it's instructed to us is that we're trying to capture deep, long air, and that's, it has to be a sufficient sample size to capture that. In this case, I had no reason to believe that was not a sufficient sample, or that it was an issue. I mentioned an O2O green, that's O2O 0.020 referring to breath alcohol content. The sample in terms of breath alcohol content are 2 different, and that itself is an issue. That was not an issue in this case.
Okay. So you mentioned deep lung air. So if you provide too much deep lung air into the Intoxilizer 8000, what does that do to the reading?
I've never heard of such a thing, too much deep lung air.
Okay. No further questions, Your Honor?
Mr. Hill.
We don't have any further questions, Your Honor.
You may step down.
Thank you, Your Honor.
We rest, Your Honor.
Any evidence from the defendant?
None at this time, Your Honor.
Do you have any authority on this, your objection that the whole manual has to be be moved on park?
Your Honor, I can get the authority on it, I don't have it with me presently, but regardless of that fact, the manuals are available online. So at a minimum, the state could put it on a flash drive as they do with all sorts of other evidence. So I think a failure to present the entire manual and only to present parts of it, or what's been represented to be parts of it, is fatal to allowing it into evidence.
Well, give me some authority on that, I'll give you a week.
I'll give you the book. I mean, honestly.
Your Honor, we've already rested and it wasn't admitted into evidence.
I took your objection under advisement, so if you got an authority, give it to me. If you don't, it'll be submitted and I'll make a decision based on what I have.
Yes, sir.
All right, so that's, I need something by the 16th. I'll put it on the on my private docket for the 16th to make a decision. Well, if you file something, then I'll give the state some time to respond to it. So give me something by the 16th, so I'm not going to look at it until the 16th. All right, we have another case? Okay, we got another case.
State of Ohio versus Corey L. Whittle, case number CRB 23194A and B, CRB 23195, CRA 22405, CRB 23283.
Your Honor, I contacted Mr. Little this morning when I noticed he hadn't gotten here. He said he's out of town, unable to be here today. I told him I would seek a continuance, so I'm making a motion for continuance.
I asked for a bench warrant, Your Honor.
The bench warrant issue.
Thank you.
Well, I'm sorry that you had to stick around all this time just for that. If I'd known, I could have done it earlier.
That's all right.
All right. Warrant will be.
They're sorry.
Oh, yeah, we got officers here too.
Oh, sorry, guys. Somebody had told me I would have got knocked this out earlier. Okay. Warrant for Corey Little and court's adjourned. There are snacks in my office.
I already gave them out.
Oh. I was going to eat some of them. I got it.
The Twinkies, you mean?
The Twinkies.
Yeah.
There's orange Twinkies.